and starting the transmission. Hello. I was gonna just be done for the day, but I really want to get to Clarence Thomas's side of the story here. We're about halfway done through Anita Hill's side of the story. And so I was gonna just watch this on my own. I thought, well, I might as well stream it. So some of my best friends could come in and watch it with me. Let's go. Let's go. So this is exactly where we left off, I think. I think this is exactly where we left off. And so they're going on a break right now. She's scooting out around.
All right. Through what I know to be inadvertence, the statement that was given to Professor Hill was also for the first time, the affidavit was also for the first time made available to the committee at large without the knowledge of the senator from Pennsylvania, realizing that we did not have it either. There has been an agreement from the outset of this proceeding because, as I said, this is not a trial. This is a hearing to seek the facts, that everyone on the committee would be have made available to them any and all documents that are produced for whatever reason before there is any introduction of such documents in the record or before there is any questioning on any documents. That applies to Professor Hill, that applies to Judge Thomas, that applies to all our witnesses. Now again, I think this was, in this case, inadvertence, the way it came about, and in order, the Senate has indicated to us they wanted this very important and difficult matter resolved, and they gave us essentially 48 hours to get ready for this. So there's going to be a lot that drops between the cup and the lip here, but one of the things that will be from this moment on any document that all members of the committee have not had in sufficient time to examine, read, think about before it even is presented, if there are any to be presented or questioned on by of a witness. You want to say something, Mr. Thomas? You look like were you seeking recognition?
No.
No. With that, I now, and while we're doing a bit of housekeeping here in such an important matter, let me suggest that, again, what is the committee's intention in terms of timing. The committee's intention is to go back to Senator Specter, and he indicates he may have more questions than his next half hour, and Senator Leahy's indicated that he has some more questions. It is my sincere hope, Professor Hill, that we do not keep you much longer. And what we will do at the conclusion of Senator Leahy's questioning, we will then do what I indicated at the outset. Each member who has not asked questions, all of whom have a keen interest in this matter, will have up to 5 minutes to ask a question or questions within that 5-minute period. We will then, God willing, excuse Ms. Thomas, Professor Hill, and call Judge Thomas, I beg your pardon, back this evening, and hopefully complete Judge Thomas's testimony tonight before we go tomorrow to other witnesses. I thank you for your patience, Professor Hill. And again, as we have with all witnesses, if at any point during this process, as I've indicated to Judge Thomas and to every witness before us, you have any requirement or desire to ask for a break for whatever reason, need not have any reason, you just indicate to the chair, and there will be a break. We will recess. Now, with that, let me yield to my friend from Pennsylvania, Senator Specter.
Thank you, Mr. Chairman. Mr. Chairman, as you had noted, I had not known, you had not seen the dogged statement, but in any event, the interruption gave both Professor Hill and other members of the committee a chance to see that statement. Professor Hill, a copy or copies of that statement. Copies were made available to you over the break, and I ask you now if you would have any objection to answering questions about that statement.
No.
All right, it may be that Mr. Doggett will appear as a witness. If he does, it would be appropriate to give you a chance to comment, and rather than have you come back after the fact, you can comment now. And I had, candidly, some question in my mind about asking you about this statement at all, but our lines of inquiry at this kind of a proceeding are very different from any other kind of a proceeding, but you've now had a chance to read it and you are willing to comment about it.
Yes, I will.
I bring up the statement of Mr. Doggett because of the statement which was made by Dean Cothe that you've already commented about, where Dean Cothe of the Oral Roberts Law School made the statement about fantasy, which I don't intend to repeat again, but that comes up in the Doggett statement. The Doggett statement is a long statement, and I'm going to summarize it by reading a portion of page 2, and you, of course, Professor Hill, are free to bring up any other part of it you want if you'd like to go into any of the rest of it.
Yes, you may, Senator.
Chairman, it's my understanding that if you follow this procedure by accepting this affidavit and inquiring of the witness in connection with it, that you open up a little Pandora's box because we can get all sorts of sworn statements. I see a number of them that were handed to me a little bit ago, and it seems that there's no end. It's my understanding further that there was some limit as to the number of witnesses that would be called by Judge Thomas, those interested in his confirmation, the number by Ms. Hill, and my question is, what are the rules?
The Senator makes a valid point that we had agreed to a witness list submitted by Judge Thomas or by the minority, and a witness list that it was submitted on behalf of Professor Hill, and that we were of the understanding that that was the totality of the witness list. There was an agreement that there would be no witnesses called other than those witnesses absent either side, shouldn't say either side, the entire committee being informed of and deciding on whether or not to issue a subpoena to any witness that had not heretofore been mentioned. Now, obviously, Mr. Doggett's affidavit, it would seem to me, at a minimum, will require Mr. Doggett to come forward and be under oath, at a minimum. So, by implication, we have changed the ground rules of who would be witnesses and under what circumstances. And I would suggest that that it may not be inappropriate to question Professor Hill on Mr. Doggett's statement, but not absent the opportunity of the majority to be able to question Mr. Doggett. Every witness that has been put on the witness list, I have insisted that both the majority counsel and the minority counsel both simultaneously interview that witness and listen and have an opportunity to question that potential witness, I should say. And in the case of Mr. Doggett, that has not occurred. Now, unless my colleague from South Carolina would object, it seems to me that it is not appropriate at this moment to question Professor Hill, notwithstanding her willingness to be questioned. I am told that Mr. Doggett is scheduled to be interviewed by majority and minority staff at 5 o'clock today.
This afternoon, 5 o'clock.
5 o'clock. I would respectfully suggest to my friend from Pennsylvania, it would be more appropriate to question Professor Hill on Mr. Doggett's assertions after we have had an opportunity, all parties on the committee have had an opportunity to speak with Mr. Doggett, so that other senators will have an opportunity to intelligently question Professor Hill on Mr. Doggett's statement, and after having spoken to, staff having spoken to Mr. Doggett. So unless my colleague from South Carolina would object, I would suggest we postpone any questioning on Mr. Doggett, although it may be totally appropriate to do so, until the full committee has had a chance, as per our agreement, to interview Mr. Doggett, so we are all prepared and are able to ask intelligent follow-on questions.
Mr. Chairman, I do not object, just provided that we have the opportunity to question Professor Hill after Mr. Doggett is testifying.
Professor Hill, this may mean that you would have to come back, and I'll leave the choice to you, but I would respectfully suggest it is better to us have an opportunity, all of us, to question Mr. Doggett before you are questioned about whatever Mr. Doggett had to say. Would you like time to confer with your counsel?
Yes, just a moment, please.
Thank you.
I will agree to come back, if necessary, to respond to Mr. Doggett's testimony.
Well, it may be possible. I'm not promising this. It may be possible we can do this by interrogatories or sworn interrogatories or by affidavit, but I do not make that commitment. The only commitment I'm making now is, which seems to me fair, is for the committee to be fully informed prior to your being questioned on, Mr. Doggett. Yes. Yes.
I haven't perhaps been privy to some of these agreements that have been made, but it seems to me there's nothing wrong with... I'm sorry, I apologize. It seems to me there's nothing wrong with, while the witness is here, asking her about these questions about, this particular statement. She was willing to answer it, and I think you save time by doing it. And frankly, I don't see any problem with that. And I think the senator could have.
If she's willing to go ahead, we have no objection.
He can ask any questions he wants. Maybe we won't call Doggett, but at least he should be able to ask her if this is true or if this is what happened, and she can answer. And she's had a chance to look at the statement.
Just a moment to my friend from Vermont. There's one simple reason why I would not like to go forward now. And quite frankly, it is not totally as a consequence of whether or not we're being fair to the witness, which I think would be somewhat unfair to it now. It's simply that I don't know enough to know. I want to be able to question contemporaneously the witness on this issue when she's being questioned. And it seems to me that it is, as I said at the outset, this is not a trial. We are just trying to find out the truth. And the best way to find out the truth is for everybody in this committee to have ample opportunity to review whatever is going to be introduced in evidence so that we can all intelligently question on the matter. I yield to my friend from Vermont.
Mr. Chairman, it merely echoes what you said, but I know that we have tried in fairness to everybody involved, the administration, Judge Thomas, Professor Hill, and everybody else. We've worked out ground rules that you and Senator Thurmond and the rest of the committee have agreed to. This would go out, and we've all had to develop whatever we were going to do within those ground rules. This would go outside them, and as one who has been designated to ask questions, I would find it very difficult to do any kind of a follow-up on this, not having been able to at least delved into a statement of somebody who's not going to be a witness, but whose statement would be used almost as though they had been. And for the sake of a few hours delay or whatever it might be, I would rather do it in a way that all of us, those asking questions based on the statement, those who may want to do follow-up questions based on the statement, at least know what the facts are.
Thanks.
I haven't heard of this, that you can't ask a witness questions. Now, admittedly, we may decide that we don't call this man as a witness, but it's a verified statement, as I understand it, and she may agree or not agree with it. I mean, that's going to be her privilege. But she did read it. She said she was willing to testify, and I don't see any reason why he can't ask questions about it. It's relevant to the proceedings.
Mr. Chairman, I don't think we ought to attempt to require her, but if she's willing to go ahead, then we can save time, I think.
And let me ask Ms. Hill, and then we'll end this right now. Ms. Hill, would you prefer to wait till we have had a chance to, all of us have a chance to interview Mr. Doggett or our staffs, or would you prefer to go now?
I can. That's a hard choice. If the committee
well, then the
needs
chair
some,
will make the choice. We will wait.
Okay. I can comment on the statement now. I'm not sure what the statement is supposed to mean.
That's the problem.
And it's really baffling me. I'm really confused by it, but it's meaningless to me. So, but would you
forward now or not?
Excuse me, sir. Just a moment, please. Just a moment.
I think whichever she prefers.
I agree. Whatever the witness prefers, we'll do.
Mr. Chairman, I might say that it's because the affidavit is so meaningless to me. That's why I wanted to question it further. But whatever works.
If the chairman recommends that we wait, I'm perfectly happy to wait.
I have no recommendation.
Okay. So you are going to make me decide, aren't you?
If it were left to me, I would want to abide by the rules that we had. But if the witness prefers to go, there is no problem. She may go.
Well, I would prefer that we abide by the rules that we have then.
All
Also.
right. Then we will wait.
Mr. Chairman?
Yes.
Let me ask you a question.
Yes.
We were all in the hall during the recess. The media has this affidavit, and they're not going to wait for anything.
That's true, they don't.
And so you know that.
Yes.
And I just say that to you as a lawyer, that it will be circulated. It is now going out, and there's no response from you. I would think that obviously this man should come and testify. I would think that he automatically qualifies as a witness. The other witness yesterday, Angela Wright, I was told about yesterday afternoon. They took a deposition from her yesterday, and I saw it last evening. And she said, although the headline was new and dazzling evidence, she said, quote, "I am not stating a claim of sexual harassment against Clarence Thomas. It's not something that intimidated or frightened me. At the most, it was annoying and obnoxious," unquote. So surely, if we're going to have, we are going to have fairness, and we have had fairness. But this is an extraordinary document, and it is not a statement. And nor was yours a notarized statement when you began. It is a sworn statement. It is an affidavit. And so I think that I'm ready to do anything you wish, but the feeding frenzy is on.
There is no right answer, I expect, to this, Professor Hill. And then let me finish, if I may. With regard to the person referred to by the senator from Wyoming, immediately upon us being aware that such a person existed, we immediately contacted, within 20 minutes, less time than that, staff, all staff, and any discussions that took place with that person were done jointly. But I only say that to put him at rest. We're going to end this. I see your counsel has indicated that it may best be well for you to go forward. And if that's your decision, we will go forward. Let's go forward. From now on, though, as I said, no document will be put in place until every member has had time, and we'll abide by your counsel's recommendation to you.
Mr. Chairman?
Yes.
Could I make one illumination to this?
And, sir, who are you?
Whether the Senate wants to follow its rules or not.
Sir, I beg your pardon.
Prepared to answer now or later.
Who is this?
Yes, sir, who are you?
I am Warner Gardner of Shea Gardner of this city, counsel to Ms. Hill. I'm trying to explain that she is ready to answer questions to the best of her ability now or later, and that the issue of whether or not you bend your rules a little bit
I understand that,
is not
sir.
ours.
Yes.
It is yours.
Yes. Sir, and this is the last statement I'll make on this. It is very easy for me to insist on the committee rules being followed. But you and her other counsel may rightly conclude that Senator Simpson is correct. It will mean that this affidavit will be sitting out there for 2, 4, 6, 8 hours unresponded to. That is not a judgment. Since this is not a court of law, I am not prepared to make the judgment whether or not Professor Hill, having gotten in this situation, is prejudiced by the fact that she cannot respond. That is why the chair is not going to rule that the committee rules must be adhered to. And they are not the committee rules, they are the ground rules that were laid down, what is obviously an extraordinary, unusual, and unprecedented hearing. So, ultimately, we must look to the witness and her counsel to determine what is in her best interest, not the committee's best interest. From the beginning, the interests at stake are those of Professor Hill and those of Clarence Thomas, not the committee's. Now,
Will there be an opportunity to respond to the witness if he is called?
yes, you will have an opportunity to respond today, this moment if you wish, and to the witness if he is called.
Well, then I'm ready to go forward.
Senator Specter.
Thank you, Mr. Chairman, but I think my time is up. Mr. Chairman, I would just like to say initially for the record that I did not make this statement available to the media or anyone.
I understand that, Senator.
And the
know you
ruling
better.
and the election is to proceed to questioning on the statement.
The election of the witnesses to proceed, knowing that we may call Mr. Doggett here to testify under oath, if we so deem necessary.
Thank you, Mr. Chairman. Professor Hill, I had started to question you about this affidavit and had desisted in mid-sentence because I wanted you to have an opportunity to read it, and there's a concern on my part about the document, but I think it has sufficient value, and since you are willing to respond to it, I'm going to discuss it with you briefly. This is an affidavit provided by a man who knew both you and Judge Thomas, and its relevancy, to the extent that it is relevant, arises on page 2, where Mr. Doggett says the following: "The last time I saw Professor Anita Hill was at a going-away party that her friends held for her at the Sheraton Carlton Hotel on K Street just before she left for Oral Roberts Law School. During this party, she said that she wanted me to talk in private. When we moved to a corner of the room, she said, quote, 'I'm very disappointed in you. You really shouldn't lead on women and then let them down,' close quote. When she made that statement, I had absolutely no idea what she was talking about. When I asked her what she meant, she stated that she had assumed that I was interested in her. She said it was wrong for me not to have dinner with her or to try to get to know her better. She said that my actions hurt her feelings and that I shouldn't leave women on like that. Quite frankly, I was stunned by her statement, and I told her that I felt her comments were totally uncalled for and completely unfounded. I reiterated that I had never expressed a romantic interest in her and had done nothing to give her any indication that I might be romantically interested in her in the future. I also stated that the fact that I lived 3 or 4 blocks away from her but never came over to her house or invited her to my condominium should have been a clear sign that I had no personal or romantic interest in her. I came away from her going away party feeling that she was somewhat unstable and that in my case she had fantasized about my being interested in her romantically. And on page 3, it was my opinion at the time, and is now my opinion, that Ms. Hill's fantasies about sexual interest in her were an indication of the fact that she was having a problem being rejected by men she was attracted to. Her statements and actions in my presence during the time when she alleges that Clarence Thomas harassed her were totally inconsistent with her current descriptions and are, in my opinion, yet another example of her ability to fabricate the idea that someone was interested in her when in fact no such interest existed. And then there's an affidavit. My question to you, Professor Hill, is Mr. Doggett accurate when he quotes you as saying, quote, "I am very disappointed in you. You really shouldn't lead on women and then let them down," close quote?
No, he is not.
What, if anything, did he say to you?
As I recall, before we broke, I told you that I had very limited memory of Mr. Doggett. The event that he is talking about was a party where there were 30 or 40 people. I was talking to a lot of people. There were people who I had known while I was here in Washington, and we might have had some conversation, but this was not the content of that conversation. I have very limited memory of him. I do not at any time have any fantasy about a romance with him.
In the earlier part of his affidavit, he says that he met you in 1982 at a gathering of African-American lawyers on Capitol Hill, and that he had a number of contacts with you.
Doesn't seem like a truth teller.
Are his statements in that regard accurate, if you recall?
As I said, my memory of him is limited. I do remember at some point seeing him jogging near my home, but beyond that, I have a very limited memory of any interaction that I had with him or how I might have met him, anything like that.
I'm shifting now, Professor Hill, to a key issue regarding your testimony that you moved with Judge Thomas from the Department of Education to EEOC because you needed the job. That is your testimony, correct?
Well, I think that's your summary of my testimony.
Well, is my summary accurate?
Well, I said that I moved to EEOC because I did not have another job. This position that I was not sure whether I would have the position at the Department of Education. I suppose that could be translated into I needed the job.
Okay. I am informed, Professor Hill, that you were a Schedule A attorney and in that capacity could stay at the Department of Education. Is that incorrect?
I believe I was a Schedule A attorney, but as I explained it, I was the assistant to the chair of, assistant to the secretary, Assistant Secretary of Education. That I had not been interviewed by anyone who was to take over that position for that job. I was not even informed that I could stay on as a Schedule A attorney, and as well as I stated before, the agency was subject to being abolished.
But as a Schedule A attorney, you could have stayed in some job.
I suppose, as far as I know, I could have, but I am not sure because at the time the agency was scheduled to be abolished. And I would add, too, that one of the things that I have made the point about before was that the activity had ended at that time, and I enjoyed the work. I wanted to do civil rights work, but I didn't know what work I would be doing if I could have even stayed at the agency or at the Department of Education. I moved on because I assumed that the issue of the behavior of Clarence Thomas had been laid to rest, that it was over, and that I could look forward to a similar position at the EEOC.
Well, I understand that you have given that reason that the behavior had ended, so that you have given a basis for not expressing a concern. But your statements in your earlier testimony involved your conclusion that you would have lost your job. And I'm now, excuse me?
That was one of the factors.
That was one of the factors. And I'm now asking you about the correctness of that in light of the fact that you were a Schedule A attorney, and while you would not have been Judge Thomas's assistant or perhaps the assistant of the assistant secretary, as a Class A attorney, you could have, in fact, kept your job had you wanted to stay there.
That really was not my understanding, sir, at the time. I understood that my job was going to be lost. That was my understanding.
Well, did you make an inquiry?
With whom?
Anyone?
I did not make an inquiry. I went on what I was told in my conversation with Mr. Thomas.
Well, Judge Thomas was replaced by Harry Singleton.
Yes.
And Harry Singleton, in fact, according to an affidavit provided, was prepared to retain you as one of your attorney advisors, one of his attorney advisors. Now, I pursue this in some detail, Professor Hill, because on your prior statements, as well as your testimony here, and in extensive newspaper accounts, there has been a major question raised about why you would leave with Judge Thomas, considering your statements about his sexual harassment. And I understand that you have given us part of your thinking, the cessation, so perhaps it wouldn't arise. But there's been a major basis for your leaving the Department of Education because you would have lost your job in a 25. As I recollect the press accounts in your statements, you needed a job. But on inquiry, it is determined, number one, that as a Class A attorney, you could have stayed at the Department of Education in an attorney's job. And secondly, that Harry Singleton, who took Judge Thomas's position, was ready to retain you as one of his attorney advisors had you made an inquiry. So that leads to the question, just how concerned were you about losing the job when you made no inquiry about your status to keep a job as a Class A attorney, or any inquiry with the successor Assistant Attorney General who was prepared to keep you?
Chairman, again I want to raise a question about the method of procedure. What we have now, within the last 15 minutes, we were presented 5 pieces of paper, some of which are notarized, some of which aren't, various people making certain statements. And now we find my friend Senator Specter is in, and before that we had been presented the affidavit of Mr. Doggett. Now we find that this lady is being called upon to respond to these statements, some of which are notarized, some of which aren't. But what we're doing is we're introducing a whole new element of testimony, and this means by inquiring of her. And frankly, Mr. Chairman, I feel it violates the rules under which this committee, you told us this committee was operating, which I think we all agreed to, and I think it's a backdoor way of approaching the question of how many witnesses each side will bring forth.
Mr. Chairman, if I may respond.
Yes.
This is a key point as to why Professor Hill left one department and went to another. And according to her statements, Judge Thomas had sexually harassed her at the Department of Education. And she went with him to EEOC in significant part, if not in major part, according to her statement, because she would have lost her job. Now, Senator Metzenbaum may find that uncomfortable, but I frankly object to his interruption, and the witness doesn't have any problem with the question.
Well, I want to say I'm not wanting to interrupt my friend in his line of inquiry. I'm raising the question with the chair with respect to the procedure. We were all told that there would be only so many witnesses, and unless there was agreement between the chair and the ranking member, that is the number that would be had. But if you have witnesses come in through affidavits and then inquire of Ms. Hill, I think that it just is not following the procedures.
Mr. Chairman, this is a question which goes to the heart of the credibility of what the witness has testified to as to her reason for a very critical move from the Department of Education to EEOC.
There's no question that it is as represented. The question is whether or not the remainder of the committee had any opportunity to prepare to know whether or not this was going to happen. What I'm afraid is going to happen now is by the time that Judge Thomas gets here, there will be 2, 7, 10, 12, 15 affidavits that no one will have an opportunity to look at, and Judge Thomas will be questioned on things that could be totally scurrilous, could be, in fact, totally off the wall without any of our staffs having an opportunity to determine whether or not the person proffering the statement is, in fact, credible, and whether or not that person should be called before the committee.
Mr. Chairman,
Yes.
can I make a statement?
Yes.
I think the question is proper because without this affidavit, you don't need the dogged affidavit.
Well, I would say
He could ask her the question that he did ask her, why she left when she could have stayed. Without this, you don't need this affidavit. The question he asked is perfectly proper.
Well, Mr. Chairman, just on this issue, it's being represented that Singleton had a job available for Professor Hill. I mean, I think it'd be legitimate to find out when did Mr. Singleton indicate that Professor Hill might have a job? Did he have a conversation with her prior to the time that she left the agency? Here, a senator is saying, well, don't you know that Mr. Singleton, who happens to be one of Clarence Thomas's best friends, had a job just out there, and why didn't you take it? And the fact you didn't take it must reflect something, and I think all of us know what is trying to be reflected. And so I think it's perfectly appropriate for us, when we're going to talk about asking a witness about when that job was available, to know when that job, whether Mr. Singleton talked to Professor Hill, when he talked to her, when he indicated a job was going to be available, rather than just go ask the witness right here in an affidavit. At some time, Mr. Singleton concluded, based upon your standing over there, that you would have been available. And I think that's the point the senator from Ohio is making. I think it's a legitimate.
Mr. Chairman,
if
I may respond just briefly.
Yes.
The question is whether Professor Hill asked Mr. Singleton. She is in the process of leaving. She is concerned about her job, and the question which I ask goes to the issue of her inquiry as to her ability to stay because she's in a Class A status, or secondarily to keep the same position as the Assistant Secretary's advisor. Goes to the issue of her state of mind as to whether she felt she really had to move with Judge Thomas to keep a job.
Now, wait a minute. Let me say something.
Before you rule, I'd like to make a statement.
Make it briefly, if you could.
I'll try. It seems to me that these questions are relevant, I'm sorry. It seems to me that these questions are relevant. Last night, we were trying to obtain all the knowledge we could from this so-called Angela Wright. Well, she gave so much testimony and then refused to talk after that. Now, does that mean that she's going to be barred from testifying? I don't think anybody on your side is going to argue that. He's entitled to ask her in advance what her recollection is of these things. And all that means is that she'll answer it. Either she agrees with the statement or she doesn't. If she doesn't, she doesn't. Now, if she doesn't and the Singleton statement says something else, we have an option of calling Singleton or not calling him. I mean, that doesn't take anybody's rights away from them. And I think if she wanted to, she'd have an option of coming back if she didn't like what he said. So I think, I never heard of this rule.
I thank my friend.
Mr. Chairman, I do wish to make one point on this. How fair can it be to either Professor Hill or any other witness if any of us can sit up here and say, when I have this stack of affidavits and an affidavit number 5 in the 3rd paragraph, somebody says such, what do you have to say about that? I mean, at the very least, I ought to be able to see these affidavits. At the very least, they ought to have some idea who the person is and who they're credible. Otherwise, you go down through a whole list and say, aha, affidavit number 29, second sentence, they say that you were living in Japan at the time. Can you prove that you weren't? I mean, this doesn't make much sense. That's no procedure.
I thank my colleagues for their advice. The chair rules as follows.
Mr. Chairman, may I just,
You've been very good.
I promise I've tried. It's a very difficult day for me. Mr. Chairman, let me just say, every one of us at this table is in anguish because what we're trying to deal with is the credibility of these two people, principally. And so anything that goes to their credibility, we have to hear. Forget about Doggett. I'm glad you responded. I think that was appropriate because that thing would be splattered all over the place. And if you hadn't said anything, you'd pay for it. And so now, you can't tell me what you're going to do when Clarence Thomas gets here and you bring up any questions impugning his credibility. Are we going to invoke this rule? I want to see it to believe it.
Well, let me tell you.
This is about credibility.
Let me tell you what I'm going to do. And then I'll yield to my colleagues. I'm going to speak. Let me tell you what I'm going to do. It is appropriate to ask Professor Hill anything any member wishes to ask her to plumb the depths of her credibility. It would be appropriate to ask her about Mr. Singleton. But it is inappropriate to represent what Mr. Singleton says via an affidavit. There is a distinction. So you can ask anything you want. You can ask her what Santa Claus said or didn't say, whether she spoke to him or not. But it's inappropriate to introduce an affidavit from Santa Claus prior to every member in this committee having an opportunity to check it out for the following reason. We may find out that Santa Claus is not real. Therefore, it may not be very relevant whether or not Santa Claus said something or not. So we're all lawyers on this committee with one or two exceptions. There is a fundamental distinction between being able to ask a question, to determine the credibility of a witness and representing what an individual said they said, or said they offered, or said they thought about the motivation of the witness. There's a distinction. And so the chair will rule you can ask anything you want about credibility. You cannot represent via an affidavit or a sworn statement or a statement as to what the individual being asked about thinks. If that is the case, ask the committee to bring that witness forward. And then we will sit down and renegotiate among ourselves and with the White House how many witnesses we're going to have. But as pointed out here, this is another way of getting in 2, 5, 7, 10, 20 witnesses without their being able to be cross-examined, representing what they said. Now, that is the chair's ruling. Did my friend want to say anything?
I would just buttress that by saying there's one other reason, Mr. Chairman, and that is if we don't abide by the rules, we're going to end up in these wrangles constantly every time a new affidavit is brought up.
And I assure my friend from Wyoming that I will impose the same exact rule on anyone questioning Judge Thomas. Now, the senator from Pennsylvania has the floor.
Mr. Chairman, am I accurate that I only have 29 minutes left?
You have whatever time was, let me ask Senator
29
Simpson
minutes
how
on
much
my
time.
30-minute round.
Pardon me?
Is it accurate that I only have 29 minutes left on my 30-minute round?
It's accurate. You can have as much time as you want, sir.
Thank you very much, Mr. Chairman. Professor Hill, did you know that as a Class A attorney, you could have stayed on at the Department of Education?
No, I did not at that time.
Did you make any effort to find out that as a Class A attorney, you could have stayed on at the Department of Education?
No, I relied on what I was told.
Sorry, I didn't hear you.
I relied on what I was told by Clarence Thomas. I relied on what I was told by Clarence Thomas. I did not make further inquiry.
And what are you saying that Judge Thomas told you?
His indication from him was that he could not assure me of a position at education.
Was that when you were hired or when he was leaving?
When he was leaving.
Did you make any inquiry of his successor, Mr. Singleton, as to what your status would be?
No, I did not. I'm not even sure that I knew who his successor would be at the time.
Well, was Mr. Singleton on the premises for about 4 weeks in advance of Judge Thomas's departure as the assistant? May I finish the question?
I'm sorry.
May I finish the question?
I'm sorry.
Was Mr. Singleton on the premises for about 4 weeks prior to Judge Thomas's departure for transition?
I don't recall.
Did you make any effort at all with anybody in the Department of Education to find out whether you could stay on in a job there?
As I said before, I did not make any further inquiry.
Well, how concerned were you on your decision to move with Judge Thomas to EEOC, notwithstanding your represented comments about retaining some job somewhere?
I'm sorry. Could you rephrase the question?
I'll be glad to repeat it. If you made no inquiry to see if you could stay at the Department of Education, perhaps even as the assistant to the Assistant Secretary of Education, how much of a factor was your need for a job to go along with Judge Thomas, even though he had made these reprehensible statements?
It was part of what I considered.
Professor Hill, there has been disclosed into the public milieu the records of certain telephone logs, as so much of the evidence or representations or comments about this matter. And you were quoted in the Washington Post as saying, quote, "I am terribly saddened and deeply offended by these allegations." Ms. Hill called the telephone logs, quote, "garbage," unquote, and said that she had not telephoned Thomas except to return his calls. Did you in fact say that you had not telephoned Thomas except to return his calls?
No, I did not say that.
Washington Post is in error on that statement attributed to you.
I can tell you something about that conversation.
Please do.
When that conversation was made, it was my indication that the reporter was saying to me that we have information that you talked to Clarence Thomas 10 or 11 times over this period of time that was described. That was my understanding of what she was telling me. I knew that I had not talked to Clarence Thomas, and I told her that. I said, I haven't talked to Clarence Thomas 10 or 11 times. And she said that there were telephone logs that indicated that I had.
Well, it's not a matter of talking to Judge Thomas. It's a matter of excuse me, may I finish the question? It's a matter of telephoning him. Did you tell the reporter for the Washington Post that you had not telephoned Thomas except to return his calls?
I said to her that I had not talked to Clarence Thomas 10 or 11 times over that period of time.
So she misunderstood you to say that you had not telephoned Thomas 10 or 11 times.
I think there was a miscommunication in the entire interview.
Did you call the telephone log issue, quote, garbage, unquote?
I believe that the issue is garbage when you look at what seems to be implied from the telephone log. Then yes, that is garbage.
Have you seen the records of the telephone logs, Professor
Yes, I
Hill?
have.
Do you deny the accuracy of these telephone logs?
No, I do not.
Then you now concede that you had called Judge Thomas 11 times?
I do not deny the accuracy of these logs. I cannot deny that they're accurate. And I will concede that those phone calls were made, yes.
So they're not garbage?
Well, Senator, what I said was the issue is garbage. Those telephone messages do not indicate that, which they are being used to indicate, that is that somehow I was pursuing something more than a cordial relationship, professional relationship. Each of those calls were made in a professional context. Some of those calls revolved around one incident. Several of those calls, in fact, 3 involved one incident where I was trying to act on behalf of another group. So the issue that is being created by the telephone calls, yes, indeed, is garbage.
Well, the issue which was raised by Senator Danforth, who disclosed this log in a press conference, was done so on the point that you had made repeated efforts to contact Judge Thomas, which bore on the issue as to whether he had sexually harassed you, on the approach that if he had victimized you by sexual harassment, you would not be calling him so many times. So that when you were quoted by the Washington Post as #1 calling them garbage and denying that you had telephoned Thomas, it constituted your statement that you had in fact not made those efforts to contact him. Now my question to you is, since those calls were in fact made, as you now say, doesn't that have some relevance as to whether the committee should accept your statements about Judge Thomas's sexual harassment in the context of your efforts to call him this many times over that period of time?
No.
Okay.
Machine, if you will, so we can hear you.
Oh, I'm sorry. My response is no, that those are not relevant to the issue of whether or not there was harassment. My point is this, and I believe that these are completely consistent with what you have before you in my statement. My point is that I have stated to you that I hope to continue to maintain a professional relationship for a variety of reasons. One was the sense that I could not afford to antagonize a person in such a high position. Those calls that were made, I have attempted to explain. None of them were personal in nature. They involved instances where I passed along casual messages or instances where I called to either find out whether or not the chairman was available for speech acting on behalf of someone else, and that no, they have very little, if any, relevance at all to the incidents that happened before those phone calls were made.
Very little relevance, but perhaps some?
I believe they have none. We may differ on that.
You say that they were all professional, and you have accounted for a number of them in your statement, but a number of them have not been accounted for. For example, the log on January 30th, 1984, quote, "Just called to say hello. Sorry, she didn't see you last week." May 9th, 1984, please call. October 8th, 1986, please call. Taking the one, just called to say hello. Sorry she didn't see you last week. First of all, is that accurate?
As I indicated earlier, I do not deny the accuracy of these messages.
You had picked out one of the calls in your statement, which appears on page 8 as follows. In August of 1987, I was in Washington and I did call Diana Holt. In the course of this conversation, she asked me how long I was going to be in town, and I told her. Now, the log says Anita Hill, 547-4500, 4 o'clock, in town till 8:15, stated August the 4th. Now, if the log represents your making the statement in town till August 15th from August 4th, some might interpret that as a suggestion that you would be available to meet. Maybe, maybe not, but some might suggest that. If, on the other hand, Judge Thomas, the secretary, asked you how long you were going to be in town, the initiative would come from her and would contain no possible suggestion of your availability to meet. My question to you is, how do you know today that on August 4th, 1987, she asked you how long you were going to be in town, as opposed to your saying that you would be in town till August 15th?
That is my recollection of how the telephone conversation took place.
And your representation is to this committee that you have a recollection at this moment that Judge Thomas, the secretary, asked you how long you were going to be in town, as opposed to your volunteering the statement to her. You have an active recollection of that.
That is my recollection.
Okay.
May I comment on that telephone call? Sure. I was actually in town until the 20th of August. So at least this may be an accurate representation of what was written in the log, but that is not an accurate representation of my activities.
What relevance does that have?
Well, my point is, you asked if these phone messages were accurate, and I said that I would not deny their accuracy, but I will deny the accuracy of that as a representation of my activities.
Let me return, Professor Holt, to the question as to how you first came to be contacted by the Senate, and I would appreciate it if you would tell us when the first contact was made, by whom, and the circumstances.
On September 4th, a woman named Gail Laster called me, and a message was left at my office.
On September 4th?
On September 4th. September 4th. Gail Laster.
You say the person was who?
Gail Laster. And I don't have the message in front of me, but the indication was that she was working with a Senate office, and I can't.
And what happened next?
At some point in between, on September 4th, I must have returned her call, or she on her own initiative called back on September 5th, and I returned her call on that same day.
Well, now on September 4th, did you call back, or on September 5th, did she call you again?
On September 4th, I called back.
And did you talk to someone?
I left a message.
What happened next?
On September 5th, she called me.
And what was the content of that conversation?
I returned her call on September 5th, and during that call, she asked me if I knew anything about allegations of sexual harassment.
Do you have notes of these matters, Professor Hill? I
No.
see you reading from something there.
Yes, I do. I have notes that I have made.
Did you make those notes contemporaneously with the event?
No, I did not.
When did you make the notes?
I made these notes yesterday.
Okay. What was the conversation that you had on September 5th with, you say, Yale Laster?
G-A-I-L, Laster, L-A-S-T-E-R.
And what was the conversation which you had with Gail Laster?
She asked me some general questions. Then she asked me if I knew anything about allegations of sexual harassment or tolerance of sexual harassment at the office of the EEOC, in particular as they related to Clarence Thomas.
And what was your response?
My response was that I did not have any comment on either of those.
And what did she say when you told her that you had no comment, as opposed to no knowledge of any tolerance or sexual harassment?
I believe we might have gone on to something more general about the nomination. I don't believe the conversation lasted very long after that.
Well, what was in the conversation?
As I said, we went on to more general matters regarding the nomination. Issues about...
You don't recall the specific contents of the conversation?
Oh, we talked about general issues involving women in the workplace, what I thought of his views on that, on those issues.
What happened next?
On September 6th, Ricky Seichman called me. I returned the call on that day, and she asked me some specific questions about some work that I had done at the Department of Education. We spoke about that work, and she asked what role I played in doing it. And then she again asked me about rumors or did I know anything, or had I heard any rumors while I was at the EEOC involving his tolerance, Judge Thomas's tolerance of sexual harassment.
And what response? Yep.
Thank you. Or whether I knew anything about his actually engaging in sexually harassing acts.
And what was your response?
At that point, I told Ms. Seidman that I would neither confirm nor deny any knowledge of that.
Anything further in that conversation?
At that point, I think, again, we might have moved on.
Might have moved on, or do you not recall the specifics of the conversation?
But I will complete my thought here. At that point, she said, "Are you saying that you will neither confirm or deny your knowledge, or are you saying that you will neither confirm or deny that the actual harassment existed?" And I told her it was the latter.
What happened next?
I told her that I wanted to think about it and that I would get back to her.
Think about what?
Think about this issue of sexual harassment.
Did that conclude the conversation?
That concluded the conversation.
What happened next?
I think in the interim, on the weekend of September, over the weekend of September 7th or 8th, I spoke to Ms. Seidman again. I did speak to her again, and I asked her specifically, if I were to discuss this matter, where should I go? That I wanted to talk with someone who was knowledgeable about the issue before I proceeded to tell what I knew. At that point, what I was trying to do was to really determine, get some sense of how the committee would approach this and give some, take some effort to weigh what I thought was valuable information. But I wanted to do it from a more objective viewpoint.
And what did Ms. Seidman tell you?
At that point, she told me that she knew someone who worked on the Senate Labor Committee, James Brudney, who would have information, who had worked in the areas of sex discrimination, and that he would be able to give me some indication of the law, and that she also said that she had his telephone number.
Well, why would you need someone to give you an indication of the status of the law, considering your own knowledge of sexual harassment and the fact that you had been a civil rights professor at Oral Roberts Law School?
I had not practiced in the area. I have never actually practiced in the area. I've taught in the area, but it's been, I haven't taught in the area since 1986, and I understand that this is a very fast developing area of law. In addition, I wanted a more objective evaluation of my situation, and I wanted to do it with someone who I could trust. I knew James Brudney, and I wanted to talk with him so that I might be able to make that evaluation.
So Ms. Seidman recommended Mr. James Brudney.
She gave me his name, and I indicated that he was someone who I knew and who I thought had integrity and who I could trust with confidential information.
Okay, and then you did talk to Mr. Brudney?
Yes, we talked.
And when was that?
Well, we talked on the weekend of September 7th and 8th.
And what was the content of that conversation?
Actually, I'm sorry, that's incorrect. We talked on September 9th. The content of the conversation was really tell me something. What do you know about the development of sexual harassment? If I disclose to you certain facts, can you make an evaluation of some kind as to what kind of legal conclusion one might make?
So that at that time there was a doubt in your mind as to whether Judge Thomas was in fact guilty of sexual harassment on the facts as you knew them.
Well, I want to back up and say something here. In my statement to you, I never alleged sexual harassment. I had conduct that I wanted explained to the committee. My sense was, my own personal sense was, that yes, this was sexual harassment. But I understood that the committee with their staff could make that evaluation on their own. So I didn't have any doubts, but I wanted to talk with someone who might be more objective.
Well, you did call it sexual harassment in your extensive news conference on October 7th, even though you did not so characterize it to the FBI or in your statement to this committee.
But that news conference on August 7th had not taken place at the time, or excuse me, on October 7th had not taken place at the time that this conversation was made.
Well, the statement to the committee and the statement to the FBI hadn't taken place either.
The statement to the FBI had not, you're right.
So that you made statements to the FBI during the week of September 23rd, and you furnished this committee a statement on September 23rd, both of which occurred after your conversation with Mr. Brudney, but in neither of those statements did you conclude that Judge Thomas was guilty of sexual harassment.
I had reached, in either of which statements?
You did not tell the FBI that Judge Thomas was guilty of sexual harassment, did you?
I don't recall telling them that he was guilty of sexual harassment. No,
well, you didn't characterize his conduct as sexual harassment.
I did or did not?
You did not characterize Judge Thomas's conduct as sexual harassment when you gave the statement to the FBI, correct?
Well, Senator, I guess I'm not making myself clear. I was not raising a legal claim in either of my statements. I was not raising a legal claim. I was attempting to inform about conduct.
But you did raise a legal claim in your interview on October 7th.
No, I did not raise a legal claim then.
Well, I will produce the transcript which says that it was sexual harassment.
Well, I would suggest that saying that it is sexual harassment and raising a legal claim are two different things. What I was trying to do when I provided information to you was not say to you, I am claiming that this man sexually harassed me. What I was saying and what I state now is that this conduct took place. You have your own legal staff, and many are lawyers yourselves. You can investigate and determine whether or not it is sexual harassment. And that's one of the things that I want to get away from. Were I filing a claim, if I were filing a complaint in court, this would be done very differently. But this does not constitute a legal complaint.
So that you are not now drawing a conclusion that Judge Thomas sexually harassed you.
Yes, I am drawing that conclusion. That
well,
is
then
my...
I don't understand.
Pardon me?
Then I don't understand.
Well, let me try to explain again. I brought this information forward for the committee to make their own decisions. I did not bring the information forward to try to establish a legal claim for sexual harassment. I brought it forward so that the committee could determine the veracity of it, the truth of it. And from there on, you could evaluate the information as to whether or not it constituted sexual harassment or whether or not it went to his ability to conduct a job as an associate justice of the Supreme Court.
But Professor Hill, there's a big difference between your articulating your version of events contrasted with your statement that Judge Thomas sexually harassed you. And in the transcript of your October 7th interview, you responded to a question saying that it was sexual harassment.
In my opinion, based on my reading of the law, yes, it was. But later on, immediately following that response, I note to the press that I did not raise a claim of sexual harassment in this complaint. It seems to me that the behavior has to be evaluated on its own with regard to the fitness of this individual to act as an associate justice. It seems to me that even if it does not rise to the level of sexual harassment, it is behavior that is unbefitting an individual who will be a member of the court.
Well, Professor Hill, I quite agree with you that the committee ought to examine the conduct of the behavior and make a factual determination of what you say happened and what Judge Thomas said happened. But when you say that you had not made the statement that he had sexually harassed you, that is at variance with your statement at the October 7th news conference.
Senator, I would submit that what I said was I have not raised a claim of sexual harassment in either my statements. And I will say again that in the news conference, I was simply stating that yes, in my opinion, this does constitute sexual harassment.
Okay, back to Mr. Jim Brudney. You consulted with him because you wanted some expert advice on what...
I'm not going to interrupt you, but your time is up. But you finish this. Go ahead. Finish this line, and then we'll move to our friend from Vermont. But I just wanted you to be aware to start.
I'm sorry, I
the line.
hadn't noticed.
That's all right. No, there's no reason why you should have. That's
I had recollected your statement. Take as much time as you want. That might.
No, that's true. Go right ahead. Finish this line, and then we'll go to our friend from Vermont. I just wanted to sort of alert you to start to wind down.
Well, this is not necessarily brief because I think it is important to develop the facts as to the contacts which end up with the issue as to whether the USA Today report is correct that, quote, Anita Hill was told by Senate staffers her signed affidavit alleging sexual harassment by Clarence Thomas would be the instrument that, quote, quietly and behind the scenes, close quote, would force him to withdraw his name.
Well, then I understand, and I assume that's where the senator was going.
Right.
And since that will take a little more time, why don't we
That's fine
break
with me,
here?
Mr. Chairman.
And let me ask, because there's a lot of pressure for any witness sitting under the lights this long. Would you like to take a break now? Would you rather? Now, before everyone starts to get up and go, let me tell you what we're going to do from here on, if I can. It is our hope and intention that shortly we will take a break. We'll then come back to Senator Leahy. And then we will, although we agreed we would stop at this point, the purpose of this is fact-finding, so we're going to continue. If there's questions my friend from Pennsylvania has and my friend from Vermont may have, speaking for me and for Senator Heflin. But we're going to try to finish with the witness relatively soon, and then we will break for dinner, and it is the intention of the chair to have Judge Thomas back. In fairness to him, he should have an opportunity tonight and not have to wait to respond to what has been asserted. And so that's how we'll proceed. 10 minutes, good? 10 minutes. We'll recess for 10 minutes.
Okay.
Welcome back. Now, again, we are waiting to hear.
Before he starts, I just want to say how much I love you guys. This is much less boring without you. Wait, yes.
From Judge Thomas, whether he wishes to. I know there's a few people in the press, and we're anxious to know what. I have made a commitment. I think it's only fair that the Judge Thomas can come on whenever he wishes after Professor Hill finishes. He has not made that decision whether he wishes that to occur tonight or not. If he wishes to occur tonight, we will go tonight, and we will go as long as is appropriate or is reasonable, and I can't guess what that would be at this moment. So I apologize to those who are trying to set their schedules, but again, as I said, this is not a trial, this is a fact-finding mission, and we are going to be as fair as we can to all parties. Now, let me suggest that, as it appears now, we have Professor Hill, two more principal questioners who will question you, roughly a half hour apiece. And then we're going to yield, as I indicated at the outset, to any of our colleagues who wish to ask up to 5 minutes. It is my sincere hope that they will have concluded that all the questions that they wish to have asked will have been asked. So we'll be a minimum of another hour and a maximum of another hour and 40 minutes or thereabouts. We will then break for dinner if Judge Thomas wishes to come back. It will break for roughly 45 minutes to an hour for dinner. If he does not wish to come back, we will just recess until tomorrow morning, and we'll have to decide on the time when I speak to the ranking member, whether it's 9 or 10 o'clock tomorrow morning. I see my friend from Wyoming seeking recognition. Does he?
Mr. Chairman, I think that all should be aware that I feel rather positive that Judge Thomas does want to be here this evening. Whether it can be concluded or not, I don't know. But
I guarantee that he will be then.
It will be fair, I know.
So, thank you for your patience, Professor Hill, and for everyone else's. Let us now turn to the Senator from Vermont, Senator Leahy.
Thank you, Mr. Chairman. Professor Hill, let me go back to some of the areas we were leaving, and I'd like to refer first to a comment just made by the chairman, and then I want to go into a couple of the questions by Senator Spector. The chairman said, and quite rightly, that this is not a trial. We're not having a trial on whether sexual harassment under the statute was fulfilled or not, and whether the statute of limitations failed or not. We're trying to find what the facts are. And with that in mind, I go to the questions Senator Spector was asking you. And he talked about whether you would call this sexual harassment in your FBI statements. In your Norman, Oklahoma, October 7th press conference, you were asked, Professor Hill, you said that you did not describe this as sexual harassment in your FBI statement. You answered, I described the incidents. I did not use the term sexual harassment. Let me go, if I might, and please just bear with me a couple minutes on this. Let me go to your earlier statement today, sworn statement. And you talked of Judge Thomas calling into his office and then saying, and I quote from your statement on page 3, after a brief discussion of work, he would turn the conversation to discussions of sexual matters. His conversations were very vivid. He spoke about acts that he had seen in pornographic films involving such matters as women having sex with animals and films showing group sex or rape scenes. he talked about pornographic materials depicting individuals with large penises or large breasts involved in various sex acts. Now, without saying whether you felt that fulfilled a specific statutory definition of harassment, tell us in your own words, Professor Hill, after one of those conversations, how did you feel?
I was embarrassed. I found this talk offensive, completely offensive. It was, I made the point that it was offensive, and it was something that was thrust upon me. It was not something that I voluntarily entered into, and therefore it was even more offensive. It was just the nature of the conversation was very offensive and disgusting and degrading.
And without going into a statutory description of what is or is not sexual harassment, how did you feel after, and I quote from your statement, on several occasions Thomas told me graphically of his own sexual prowess. How did you feel then?
That was really embarrassing because I thought it even personalized it more to the individual who I was looking at. I mean, it's one thing to hear about something that someone has seen, but it's another thing to be face to face with an individual who is describing to you things that they have done. And that was very embarrassing and offensive, and I did not like it. I felt it was just, I mean, it's hard for me to describe. It just made me feel very bad about the whole situation.
And on page 5, without repeating it again, you spoke of his discussions he'd had with you, himself, and other women. Is that correct?
I'm sorry. Yes.
Professor Hill, you've spoken to us all being lawyers, and we read the statute and the code words of the statute. Let me just ask you one more time. Did you consider that, at least as it involved you, harassment?
Yes, I did.
Thank you. Now, Professor, we have spoken in other questions of phone logs. Have you seen the phone logs that Senator Danforth released? I believe the New York Times and Washington Post, others had had articles about it.
Yes, I have seen that.
Now, you left the EEOC in 1983. Is that correct?
Yes.
Judge Thomas left the EEOC in 1990. Is that correct?
As far as I recall.
Approximately 7 years in there.
Yes.
If you count up the phone calls that are shown on those phone logs, assuming that they're accurate, that amounts during the 7 years, what, a dozen phone calls?
I think there were described as 10 to 12 or 10 to 11 phone calls.
It's about 1.5 a year.
Yes.
Assuming those phone logs are accurate, you weren't exactly beating down the doors with phone calls there, were you?
I was not at all.
Now, there was a question of Mr. Doggett. Do you have any strong and clear recollection of Mr. Doggett at all?
No, not at all.
Without doing here, could you, if you were asked to, would you be able to accurately even describe him?
I could not with any specificity describe him. I think I remember him as being tall.
Happens to a lot of us. Who was the legal counsel at EEOC when you started there in the spring of '82?
The legal counsel was Constance Dupree, or let's see.
Beg pardon?
Legal counsel, I believe, was Constance Dupree at the EEOC.
Did there come a time when there was a change made in this position? After
Yes.
after you went to EEOC?
After I went to the EEOC, I believe she retired from the government service altogether, but she left that position.
Was it a short time after you arrived, a long time after you arrived, do you recall?
Oh, I believe it was about midway, maybe 4 or 5 months. Maybe it may have been shorter than that.
Who became legal counsel then? Do you recall?
I do not recall the individual's name.
Now, in one of the, in testimony, or an interview this morning, the witness stated that you, and this is an interview where you have not seen the transcript, but both the Republican and Democratic counsel were there, but they said that you had expressed your desire to have the legal counsel's position. Had you done that had you expressed such a desire at the time that the vacancy occurred, the one you just described?
No, I did not express any desire for that position. I had no desire for such a position. I was just new to the EEOC.
So did you have conversations with an Armstrong Williams about getting that job, the job of legal counsel?
No, I did not.
And you do not recall applying for the job of legal counsel?
I did not.
Now, Senator Specter spoke of concern. Well, let me read. I want to be fair in my phrasing of it. He questioned you at some length about following Judge Thomas from the Department of Education to the EEOC. Is that correct?
Yes.
And am I correct in restating your testimony that those conversations, which you now describe as just during these questions described as harassment, those conversations began at the Department of Education, is that correct?
Yes, that is correct.
But notwithstanding that, you went to the EEOC when Judge Thomas went there?
Yes.
Do you recall, prior to going to the EEOC, how long before that had been the last conversation of the nature that you have described here with Judge Thomas? Those conversations that you found offensive, how long prior to your transfer had one of those occurred?
I would say 4 months or so, about 4 months.
Some time, in fact.
Sometime.
Now, did anybody tell you that you could stay and have a job at the Department of Education?
Nobody told me that.
Had President Reagan pledged and campaigned on such a pledge that he would do away with the Department of Education if elected?
Yes, he had, and that was the understanding within the department itself. The individuals who were working in the department understood that to be the case.
And President Reagan was then president?
Yes, he was.
And nobody told you that there would be a job in the Department of Education where you could still work in civil rights, is that correct?
Nobody told me that.
But you did want to work in civil rights?
Yes, I did.
According to your testimony. Now, walk me through again, please, what was the nature of the job that would be available to you at EEOC? How did you hear about it? What did you do to apply for it? So forth.
I did not apply for it. I heard about it from Judge Thomas. He indicated to me that I could go with him to the EOC and I would have the same type of position that I had at the Department of Education.
And that was?
That of a special assistant who would be working directly under him, advising him on a number of projects and issues that came up.
Now, Professor Hill, you've told us of the conversations. In answer to questions today, you have elaborated even on this statement that you gave us early on. Is that correct?
Yes, I have.
Is there anything you would change, either in your statement or your answers that you have given us today about the kinds of conversations that you had with Judge Thomas that you say were so offensive?
No, sir, I would not change anything. Excuse me.
How did you feel at the time you had those conversations?
During the time that
How did you feel at the time you had those conversations?
During the time that I had those conversations, I was very depressed. I was embarrassed by the type and the content of the conversation. I was concerned about whether or not I could continue in my position.
Now, that was years ago. As you recount them today, how do you feel today?
Today I feel more angry about the situation. Having looked at it with hindsight, I think it was very irresponsible for an individual in the position of the kind of authority, as was Mr. Thomas at the time, to engage in that kind of conduct. It was not only irresponsible, in my opinion, it was in violation of the law. Now I'm much more divorced from it. I'm less embarrassed by the fact that I went through that after having gone through what I've gone through now. I'm less embarrassed by it. It's still embarrassing. It's embarrassing that I didn't say anything, but I'm angrier about it, and I think that it needs to be addressed by this committee.
Do you have anything to gain by coming here? Has anybody promised you anything by coming forth with this story now?
I have nothing to gain. No one has promised me anything. I have nothing to gain here. This has been disruptive of my life, and I've taken a number of personal risks. I've been threatened, and I have not gained anything except knowing that I came forward and did what I felt that I had an obligation to do, and that was to tell the truth.
And my last question, would your life be simpler, quieter, and far more private had you never come forth at all?
Yes, Norman, Oklahoma is a much simpler, quieter place than this room today.
I have a good friend in Norman, Oklahoma, and I've actually visited Norman, Oklahoma, and I agree with you. Mr. Chairman, that's all I have.
Thank you. Mr. Chairman?
Where you went?
Inspector. I think he wants another round.
Senator Spector, you want to proceed?
We'll set the clock at 30 minutes again, Senator. Will we need that much, you think?
Chairman, I hope to conclude in less time than that. I would
Thank you.
want to finish the chronology, if I may, Professor
do.
Hill. When my time expired, we were up to the contact you had with Mr. Brudney on September 9th. If you could proceed from there to recount who called you and what those conversations consisted of as it led to your coming forward to the committee.
Well, we discussed a number of different issues. We discussed, one, what he knew about the law on sexual harassment. We discussed what he knew about the process for bringing information forward to the committee. In the course of our conversations, Mr. Brudney asked me for specifics about what it was that I had experienced. In addition, we talked about the process for going forward, what might happen if I did bring information to the committee. That included that an investigation might take place, that I might be questioned by the committee in closed session. It even included something to the effect that the information might be presented to the candidate or to the White House. There was some indication that the candidate, or excuse me, the nominee, might not wish to continue the process.
Mr. Brudney said to you that the nominee, Judge Thomas, might not wish to continue the process if you came forward with a statement on the factors which you've testified about?
Well, I'm not sure that that's exactly what he said. I think what he said was, depending on an investigation, a Senate, whether the Senate went into closed session and so forth, it might be that he would not wish to continue the process.
So Mr. Brudney did tell you that Judge Thomas might not wish to continue to go forward with his nomination if you came forward?
Yes.
Isn't that somewhat different from your testimony this morning?
My testimony this morning involved my response to this USA newspaper report. And the newspaper report suggested that by making the allegations that would be enough, that the candidate would quietly and somehow withdraw from the process. So, no, I do not believe that it is at variance. We talked about a number of different options, but there was never suggested that just by alleging incidents that would cause a candidate or the nominee to withdraw.
Well, what more could you do than make allegations as to what you said occurred?
I could not do any more, but this body could.
Well, but I'm now looking at your distinguishing what you have just testified to from what you testified to this morning. This morning, I had asked you about just one sentence from the USA Today News, quote, Anita Hill was told by Senate staffers that her signed affidavit alleging sexual harassment by Clarence Thomas would be the instrument that quietly and behind the scenes would force him to withdraw his name. And now you're testifying that Mr. Brudney said that if you came forward and made representations as to what you said happened between you and Judge Thomas, that Judge Thomas might withdraw his nomination.
Well, I guess, Senator, the difference in what you're saying and what I'm saying is that that quote seems to indicate that there would be no intermediate steps in the process. What we were talking about was process. What could happen along the way? What were the possibilities? Would there be a full hearing? Would there be questioning from the FBI? Would there be a questioning by some individual members from the Senate? We're not talking about or even speculating that simply alleging this would cause someone to withdraw.
Well, if your answer now turns on process, all I can say is that it would have been much shorter had you said at the outset that Mr. Brudney told you that if you came forward, Judge Thomas might withdraw. That is the essence as to what occurred. No, it is not. I think we differ on our interpretation of what I said. Well, what am I missing here, Professor Hill?
Let the witness speak in her own words rather than having words put in her mouth.
Mr. Chairman, I object to that. I object to that vociferously. I'm asking questions here. If Senator Kennedy has anything to say, let him participate in this hearing.
Now, let everybody calm down. Professor Hill, yes. Give your interpretation to what was asked by the senator, if you would, and then he can ask you further questions.
My interpretation is...
Speaking machines, so we can all get it back.
Okay. I understood Mr. Spector's question to be, what kinds of conversation did I have regarding this information? I was attempting, in talking to the staff, to understand how the information would be used, what I would have to do, what might be the outcome of such a use. We talked about a number of possibilities, but there was never any indication that by simply making these allegations that the nominee would withdraw from the process. No one ever said that, and I did not say that anyone ever said that. We talked about making the form that the statement would come in. We talked about the process that might be undertaken post-statement, and we talked about the possibilities of outcomes. And included in that possibility of outcomes was that the committee could decide to review the points and that the nomination, the vote could continue as it did.
So that at some point in the process, Judge Thomas might withdraw.
Again, I would have to respectfully say that is not what I said. That was one of the possibilities, but it would not come from my simply making an allegation.
Professor Hill, is that what you meant when you said earlier, as best I could write it down, that you would control it so it would not get to this point?
Pardon me?
Is that what you meant when you responded earlier to Senator Biden, that the situation would be controlled, quote, so that it would not get to this point in the hearings?
Of a public hearing? In entering into these conversations with the staff member, what I was trying to do was control this information, yes, so that it would not get to this point.
Thank you very much.
Now, what we'll do is we'll begin, and I thank you, Senator. Professor Hill, with your continued indulgence, what we'll do is we'll now yield to my colleagues in alternating and limit their questions to 5 minutes, if I may. And I would begin with my friend from Massachusetts, Senator Kennedy.
Thank you, Mr. Chairman. I'll just take a moment. I know this has been an extraordinary long day for you, for Professor Hill. It obviously has been for Judge Thomas as well, and I know for your family. And I just want to pay a tribute to both your courage in this whole procedure, and for your eloquence, and for the dignity in which you've conducted yourself. And it's quite clear from observing your comments for the anguish and pain which you've had to experience today and share with millions of Americans. This has been a service. We clearly have to make a judgment, but it certainly, I think, has been a very important service.
And let me just say, as far as I'm concerned, I think it's been enormously important to millions of Americans. I don't think that this country is ever going to look at sexual harassment the same tomorrow as it has ever any time in its past. And if we are able to make some progress on it, I think history books will show that it's, to a very important extent, it's because of your action. The viciousness of harassment is real. It's experienced by millions of people, I hope, as a form of sex discrimination, and I think all of us are hopeful that we can make progress on it. I just want you to know that I believe that you will have made an important contribution if we do. Thank you, Mr. Chairman.
Thank you.
Thank you, Senator. Senator Thurman.
Thank you, Mr. Chairman. Mr. Chairman, I appointed Senator Specter to question Professor Hill and those supporting her, so I will now yield my time to him.
Well, with an additional yielding, Mr. Chairman, I would just join in thanking Professor Hill for coming forward. I would join in the comment that this proceeding has been illuminating to tell America what is the law on sexual harassment. That is something which had not been known, and from what I have heard in the last few days, there has been a lot of change in conduct in the workplace in this country. I just would have wished in retrospect that we had done this earlier and that this educational process had not come in this forum on a Supreme Court nominee at this stage. But you have answered the questions, and I join in thanking you for that.
Senator Metzenbaum.
Ms. Hill, I couldn't help but think of my own 4 daughters as you sat there and thought to myself how much courage and commitment, concern, but even more than any, the valor to come before the United States Senate and speak out in areas so sensitive and I'm sure so difficult for you to talk about. And I don't know what impact your testimony will have on the confirmation process, but I know that your testimony will have a tremendous impact on this nation from henceforth. The women of this country, I'm certain, owe you a fantastic debt of gratitude for bringing this issue of sexual harassment to the fore. But as one of those 98 men in the United States Senate, I think I speak for all of us, and I say we owe you a debt of gratitude as well for bringing this issue up to the fore in a more striking, more sympathetic, more concerned manner than ever before. I think you've made this nation, men and women alike, more enlightened, more aware, more sensitive, and the nation will never be the same thanks to you. Thank you.
Senate, there will be order in chamber, and I'm serious when I say any outburst at all, no matter how small, will result in the police removing whomever does from the chamber. Now, Senator Hatch.
Thank you, Mr. Chairman. I've been pleased to sit here and listen today, and I just want to say one thing, that I apologize to you on behalf of our committee that you had to be heard under these circumstances, because had the committee considered this matter, and I have to say Chairman Biden and the ranking member Thurmond, when they heard about this the first time, they immediately ordered this FBI investigation, which was a very right thing to do. It's an appropriate thing to do. They did what every other chairman and ranking member have done in the past. And the investigation was done, and it was a good investigation. Then Chairman Biden notified everybody on his side, and many of us were notified as well. Any member of the committee, before we voted, could have put this over for a week for consideration if they were concerned. Any member could have insisted on at least an executive session where neither of you would have had to have appeared in public, or any member could have insisted on an open session. The committee could have voted. These FBI reports are extremely important, and they have raw data, raw information. They take down what people tell them. And that's why they are not to be leaked to the press or anywhere else. And that's why these rules are so important. And had an appropriate, fair procedure been followed, you would not have been dragged through the media and through all of these other things that both of you have been dragged through, that both of you have suffered from, as you have. And I have to say that I hope I never see that happen again to anybody in any confirmation proceeding on the Hill, let alone a confirmation for a justice of the Supreme Court of the United States of America. Now, having said that, I wish you well, and I won't make any further comments at this time.
Thank you very much. Senator DeConcini.
Thank you, Mr. Chairman. Professor Hill, I join in realizing the difficulty of today. It's very obvious, and I appreciate that immensely. Sexual harassment is not as new as maybe some members seem to think it is. I just remember as a young boy my mother telling me about sexual harassment and her job and losing her job. She was 22 years old. So I grew up with that in my mind, and she mentioned it several times as I grew in age. Had dinner with her night before last, and she got choked up just telling me again about it 60 years later. So it is a subject that is very sensitive. Obviously, men have a more difficult time, I believe, of understanding it. But I do believe there are many men in this Senate, in the House of Representatives and other political offices that indeed are sensitive as much as they can be as a man. Now, with that, one of the areas that intrigued me today was Senator Heflin's questions of motives. And I'm not at all indicating any diminution of your motive. What I am interested in your question, in your answers to some of those. But before I ask you that, do you see anything positive out of what you have been through here today in the last week or so, last few days, this ordeal, other than increasing the awareness of sexual harassment in the workplace? Is there any single thing you see more significant than that coming out of this?
Yes, Senator.
What do you see as the most significant thing coming out of this unfortunate experience that you have had to go through now, and I mean the public part of it?
Other than creating awareness, I see that the information is going to be fully explored. The information that I provided will be fully explored. It will be given a full hearing. In addition, I think that coming out, my coming forward, may encourage other people to come forward, other people who have had the same experiences, who have not been able to talk about them.
That would be raising the awareness of sexual harassment.
Well, raising the awareness, but also giving people courage.
And giving people courage to step forward and do what you didn't do 10 years ago or 6 years ago or 2 years ago, but you're doing today.
Yes.
Now, is your motive also to attempt to clear your name from any degrading publicity that has occurred? Do you feel put upon? Do
Coming
you feel
here today?
exposed? Do you feel injured and damaged through this, even though you obviously have committed yourself to proceed with it?
You mean my motive in coming here today? Or
Yes.
something that I think will be a positive thing from coming here today?
No, I mean, is your motive also to help clarify your own position on sexual harassment because of the publicity that has brought this up to the forefront. Is that one of your motives? Is that one of your reasons you came forward? In other words, is your reputation, was your reputation one of the reasons you came forward? You felt that your reputation was being degraded or impugned by the fact that this was printed all over the press and that people were making counter charges and questioning your motives and what have you? Is that one of the reasons?
Well, I definitely, today, coming here today, yes, I did want to accomplish that. There were a number of very ugly and nasty things that have been said, and I did want to come forward and tell my side.
Do you think, now having told your side and responded to these questions, that your reputation from your standpoint could ever be fully restored?
Not in the minds of many, never. It will not be.
And in your opinion, Professor Hill, is there any single group or entity that you think caused more damage to you? I'm interested in your perception. It seems to me that those who leaked this information certainly caused damage, and that the press, in my opinion, is on trial because they didn't have to print this, but they elected that they could do it, and in this country they can print anything they want, true or false, as we all know. And then the Senate made a judgment here, first at the committee and then in the full Senate, to put it off, and I think that is certainly on trial. Obviously, Judge Thomas is on trial, though this is not a trial. You are on trial in the sense of the credibility here. Is there any one of these that stick out in your mind? Is the committee more culpable for causing you to have to come forward? Is the press more culpable? Or is it all just a big bunch of stuff that we got to deal with and everybody's culpable?
I think it's just the reality, Senator, of this situation, the nature of this complaint, and I cannot point my finger at any one entity and say that you are responsible for this.
Well, you said earlier, and correct me if I'm wrong, that you did not want today to be what it is, that you had hoped that you could get the information to this committee, and ultimately you agreed that your name could be used among the committee members, that you had hoped that that would be sufficient for the members to make a judgment and that you would not have to do what you're doing today. Is that correct?
Yes.
Yes. Now, that didn't happen, or we wouldn't be here today. And would you repeat why you think we're here? Why did you have to come forward and make this public presentation when you had hoped to do so and to bring this information without having to do what you're doing today?
Well, I think that there are a number of factors. I think that however the material was leaked, that was one factor. I believe that the press is a factor, but I think in addition that, excuse me, that the information is just going before the public that wants to know about this. And so I think that, again, that there are a variety of situations and factors that cause this to occur today.
Let me ask you this then, if I can, Professor Hill. If this information had not been leaked, would you have suggested that you come forward and do this in a public forum?
No.
If the press had not then published it or read it to you and left you with the distinct impression they were going to publish it, if they had not done that, would you have felt obligated to come forward in a public sense other than what you'd already done?
I do not believe that I would have come forward.
You would not have come forward.
I do not believe now that I would have.
So is it safe to say that because the information was first leaked and then made public, that you felt that you no longer could proceed with what you felt was proper by letting this information available to us, but not in a public forum? Is that a fair statement?
Yes.
Thank you. Okay, Mr. Chairman, I have
Now,
a
if you
few
have
other
another question, you go ahead.
Thank you. Ms. Hill, I just, if I can, I won't be very much longer. The concern I also have is when you were at the Department of Education and these, in my terms, god-awful things occurred, grotesque, ugly, I don't know how else I can depict them, and obviously they were extremely offensive to you. When that happened to you, and you obviously did not want them to continue or participate, and you attempted to inform the person that you didn't want that, I have a difficult time understanding, and it's obviously because I'm not a woman and have not had that kind of personal experience. I have a difficult time understanding, even though you didn't have another job or anything out there, how you could tolerate that. And I realize that's part of the whole problem of sexual harassment in the job place, is because women tolerate it. And maybe you explained this sufficiently, but if you wouldn't mind repeating to me what went through your mind, why, number one, you would stay there after this happened several times, and number two, even though it ceased for a few months, why you would proceed on to another job with someone that hadn't just asked you out and pressed you, but had gotten into the explanations and exploratives and of the anatomy and what have you that you pointed out to us today.
Well, I think it is very difficult to understand, Senator. And in hindsight, it is even difficult for me to understand. But I have to take the situation as it existed at that time. At that time, those staying seemed the only reasonable choice. At that time, staying was the way that, in a way, a choice that I made because I wanted to do the work. I, in fact, believed that I could make that choice to do the work, and that's what I wanted to do. And I did not want to let that kind of behavior control my choices. So I attempted to end the behavior, and for some time, the behavior did stop. I attempted to make that effort. And so the choice to continue with the same person to another agency involved a belief that I had stopped the behavior that was offensive.
Is it safe to say then, Ms. Hill, the readings that I've done in this area and been exposed to professionals who counsel and do this, that one term is that you stuffed this inside you and went on with your life because you just were willing to kind of stuff it and keep it from exploding? Is that a safe feeling? Because I don't know. Is that?
I did repress.
We all go through that in different things that I think we all do, that we stuff certain things in and don't explode or take reaction. Is that one way of describing what you did?
I did repress a number of my feelings about it to allow myself to go on and to continue.
It's safe to say that you did this for a long period of time.
Yes, I did.
And you obviously saw Chairman Thomas move on through bigger and better positions and to be appointed to an appellate court judge and not take any action. Did you at that time again repress it and have to keep it down? Do you recall going through that any other times?
Well, at some point over the last few years, or at various points, I think that I have dealt with many of my repressed feelings about this. I've just dealt with them on my own. On your own. You didn't hire any or solicit any counseling or any assistance. You just dealt with it on your own. On my own. And finally, we're here today where it's all over, so to speak. It's all out. Not that by any means there won't be repercussion, but you finally have let it all out. Well, that is my feeling, but one has to consider that even before this point, I had dealt with the feelings of humiliation, realizing that none of this was my fault, and had dealt with a sense that I was helpless to confront this kind of a situation again. So many of the feelings have been dealt with.
Yeah, and the fact that you admit that in retrospect maybe you should have done something, you have concluded that it is all someone else's fault, none of it is your fault.
Yes.
Is that your frame of mind?
That is my frame of mind.
Thank you. Thank you, Mr. Chairman. Thank you for the additional
Thank you very
time.
much. Senator Simpson.
Thank you, Mr. Chairman. Mr. Chairman, there are two additional documents here, and I'm asking, and take your advice, from the two FBI agents who, if this has been furnished for over 2 hours under the rules, the affidavits from the two FBI agents indicating the inconsistencies as expressed by Professor Hill this morning, is that not appropriate?
That is appropriate. The inconsistencies are not of all that much consequence. At some point, maybe we should read it. I think it may be helpful for you to read the entire thing in the record.
I only have 5 minutes, Mr. Chairman.
Well, you go ahead and put in the record, and I will read them because they're not of much consequence. But well, I think we should. Let me put it this way: I think people should know what they say.
Well, I think that they should know that the witness did not say anything to the FBI about the described size of his penis, the description of the movie Long Dong Silver, about the pubic hair in the Coke story, and describing giving pleasure to women with oral sex. That is not part of the original FBI report. And the agents are simply saying that there was no pressure upon the witness, and they specifically say the woman witness, or the woman FBI agent particularly, said that she was quite clear that that she did not care whether it was general or specific. The interviewing special agent, a woman, that said if the subject was too embarrassing, she did not have to answer, but that was Professor Hill's statement. But the special agent said that the other agent, apologized for the sensitivity of the matter, but advised Professor Hill that she should be as specific as possible and give details. She was further advised that if the questions were too embarrassing, Special Agent Luton would leave the room and she could discuss the matter with Special Agent Jameson. And so I think that's appropriate only from the standpoint that you describe in your statement so poignantly, that these were disgusting things and yet they did not appear in the FBI report. That's enough. We'll enter it into the record.
I realize this is a bit unusual and the way we're doing this. My recollection was the witness had acknowledged that they did not appear in the report and had acknowledged that she had not said that to the agents as well.
That is true.
Mr. Chairman, you have your opportunity to...
No, I just wanted, because this is unusual, she hadn't had a chance to see it. That's the reason I mentioned it now. But please continue.
You're very fair. Let me ask you, I think both of you say that both Judge Thomas and you say you never met each other until 1981. Is that correct?
That is correct.
Weren't you both members of the Black Republican Congressional Staff Association?
No.
You never were?
No, I never was.
Well, I don't have enough time to go into that one. I had heard you were and that you knew him there, and the other people stated that, and perhaps that's what I was advised by a person that called me who knew you both and was there with you both, but that's enough. I'm not leaving that out there as some sinister thing. I'm just trying to find out if you knew each other before, because I heard that because he knew you there and respected you and enjoyed you there and found you very professional, that it was there he made the contact to then bring you to the Department of Education.
Which group is this?
The Black Republican Congressional Staff Association.
No, I'm not a member of that. I've never been a member of that group.
In the 70, 79, or 80, sometime in that
I was
time?
in law school in 79 and 80.
80 and 81?
In 80, I graduated from law school in 1980 and went to work in private practice here in Washington, D.C.
Okay, that's good. Thank you. That was presented to me. Now, I heard Howard Metzenbaum say, and you have presented yourself and your testimony in an extraordinary way. I did think that Senator Specter pointed out some inconsistencies. But like Howard, I thought too of my daughter, my rainbow of life. And I would be outraged if such alleged conduct occurred directed to her. And then I've had the terrible pain of also thinking of my sons.
Ethan, I'm mostly in the chat.
Raised by a very enlightened mother, responsive, still kiss their old man goodnight, and things like that, and rather expensive, stalwart boys. And where that kind of conduct could lead them.
More than one way to communicate.
Very troubling for me, because all we've heard for 103 days is about a most remarkable man, and nobody has come forward, and they scoured his every shred of life, and nobody but you and another witness apparently who's alleging no sexual harassment has come forward. And so maybe it seems to me you didn't really intend to kill him, but you might have. And that's pretty heavy. I don't care if you're a man or a woman, to know that 43 years or 35 years of your life or 60 years of your life where no one has corroborated what is a devastating charge, kind of a singular torpedo blow below the waterline, and he sinks. Well, 103 days of accumulated things never penetrated the armor. So I guess I would just say it is a very troubling thing to me. It really is. And, you know, leave out who leaked what to who or what media person let it out. That's all will be hashed. But let me tell you, if what you say this man said to you occurred, why in God's name, when he left his position of power or status or authority over you, and you left it in 1983, why in God's name would you ever speak to a man like that the rest of your life?
That's a very good question. And I'm sure that I can't not answer that to your satisfaction. That is one of the things that I have tried to do today. I have suggested that I was afraid of retaliation. I was afraid of damage to my professional life. And I believe that you have to understand that this response, and that's one of the things that I have come to understand about harassment, that this response, this kind of response, is not atypical. And I can't explain. It takes an expert in psychology to explain how that can happen. But it can happen, because it happened to me.
Well, it just seems that so incredible to me that you would not only have visited with him twice after that period and after he was no longer able to manipulate you or to destroy you, that you then not only visited with him but took him to the airport and then 11 times contacted him. That part of it appalls me. I would think that these things, what you describe, are so repugnant, so ugly, so obscene, that you would never have talked to him again. And that is a most contradictory and puzzling thing for me.
Thank you, Senator. Senator Simon.
Thank you, Mr. Chairman. First, Professor Hill, let me say to your parents, you have a daughter you ought to be very, very proud of. I'm sure you're proud of your whole family. I want to underscore what has been said by my colleagues, that you have shown great courage and you have handled yourself with dignity. And you have lifted the level of consideration of this whole question of sexual harassment as no one has done before in the history of our country. And no matter what happens on the nomination, I think you have performed a real public service. On the question of sexual harassment, you and I know, and the members of this committee know, that physical contact is not necessary for sexual harassment. But I have had two people tell me over the phone that there couldn't have been sexual harassment because there was no physical contact. If I can use another analogy that I think people would understand, if you were to receive the kind of language over the telephone that you received in an office, would you consider that an obscene phone call?
Yes.
And I think everyone understands obscene phone calls. Let me just two totally disconnected questions beyond this. You say in your statement, in February 1983, I was hospitalized for 5 days on an emergency basis for an acute stomach pain, which I attributed to stress on the job. One of the things we have to do in this committee, and my colleagues in the Senate have to do, is to make an evaluation who is telling the truth. This is something objective that happened out there. But when you say, which I attributed to stress on the job, did your physician also suggest this as a possibility?
The physician suggested that it could be stress related. They could not identify the nature of the illness. They couldn't give a medical diagnosis. So the physician did suggest that it might be stress related.
And then finally, and this has been partially touched upon, but there are those who say the timing of this is all some kind of a plot. I think the term I hear over and over. I recall calling you the day before our committee voted when we talked about the possibility of distributing this to your statement to members of the Senate. And I said, you can't do that and keep it confidential and keep your name confidential. I sensed that you were really agonizing on this whole thing, and I think I sensed correctly for obvious reasons. But this thing gradually built from the time you first contacted or had contact with the members of the Senate staff and Senate committee. Was there at any point anyone who suggested if you hold this out till the last minute, you could have a great impact on this process?
No one ever suggested that, not at all.
And then finally, let me just make a suggestion. You're always giving assignments to students at the University of Oklahoma Law School. If I could give you and your fellow faculty members at the University of Oklahoma Law School and your law students an assignment. We face a very difficult problem, and it is not just with the Thomas nomination. How do we deal with a charge that someone makes that is a substantial charge, but that person says, I don't want my name used publicly, or even I don't want the charge made publicly? We should not simply ignore it. On the other hand, how are you fair to a nominee. This is a struggle that this committee has gone through and the Senate is going through. I would be interested in you and your colleagues taking a look at that, sending a letter to members of this committee. But again, I thank you. I think you have performed a great public service. Thank you, Mr. Chairman.
Senator Grassley.
Professor Hill, let me at the outset be very candid and tell you that even though the issues that have been discussed here this afternoon and this morning are very, very important, if I had to ask some of these questions that were asked of you today, I would not be able to do that. That's just not my nature. But I have one question and a couple comments, and this is in regard to your testifying that you were approached by Senate staff members about disclosing these allegations. My question is whether or not any other individuals or any other organizations other than those who you've publicly stated today or otherwise, or Senator Specter has stated, whether any other individuals or organizations have approached you about disclosing these matters to the Judiciary Committee any time since Judge Thomas was nominated by the President on July the 1st.
No, no other organizations or individuals have approached me to disclose this to anyone. Do you mean prior to the contact from or even after that? No one has said anything?
Any time during July, August, or September, other than those names that have already been discussed here today?
No, no one has urged me to do that or even approached me about it.
Okay. Now, a couple points that I would like to make, and I suppose I'm making these more for my colleagues than I am for anybody else, but one of the hardest parts of this discussion for me is the fact that if any of our Senate employees had a complaint of sex harassment, that individual would not have the same remedy that you had available to you, Professor Hill, when you were an employee of government, particularly EEOC, although I know you chose not to make that and pursue that remedy. Because like so many laws that we pass, the United States Senate has exempted itself, or we have exempted ourselves as employers, from the coverage of Title VII, including the EEOC rules governing sex harassment. That is a situation that I hope that the Senate will soon change so that our employees will be treated fairly just like any other employees. On another point, there's been much said, and of course each of us on this committee have had to deal with this as the press has asked us how come we didn't consider all these things prior to voting this out of committee. So that deals with the process of the Judiciary Committee. People are asking how we could have let your statements slip past us. How could we have had the committee vote without airing this matter? Those are valid questions, and let me say that I'm going to work towards ensuring that this never happens again. I realize, of course, that our committee gets hundreds, maybe even thousands of allegations in a nomination like this one, and we rely upon our chairman and ranking member to determine which ones need investigation and which one might be coming from cranks and crackpots. They determined this one needed investigation, and they called in the FBI, but somewhere along the process, something broke down. So I would like to work with the chairman and ranking member and other colleagues to establish a new ground rule. Whenever the FBI is dispatched, every committee member should be notified about the nature of the allegation. And when the FBI has completed its work, every committee member should be notified and have access to that report. And a determination by the committee should be made as to how we need to proceed with any allegations. A rule like this should ensure, once and for all, that even an 11th hour charge like yours has been fully considered. I yield the floor. Or you can comment if you want to.
I would like to, for a moment, revisit your first question. I'm keenly aware that I want to be certain of my answer. The first question, it was whether or not anyone had contacted me to urge me to come forward with this. No, no one did that. Ms. Hirschner did contact me and reminded me of the situation, and we discussed the fact that we had talked about this earlier years, but she did not urge me to come forward at all.
Thank you, Mr. Chairman.
Thank you very much. Of course, the state of the law actually is that women, even in these kinds of situations, don't have adequate remedies. All they have is an injunction. They're not permitted to get any damages, which is one of the matters that's being addressed in the Civil Rights Bill.
Thank you,
Senator from Wisconsin.
Professor Hill, as you have said, this has been a difficult time for you. You wanted to make the committee aware of your experiences with Clarence Thomas, but you also wanted to preserve your privacy. And that is understandable, and we deeply regret that it has not worked out this way. But while the process may have failed you, Professor Hill, you certainly have not failed the process. For without making at this time any judgments about the ultimate truth of your claims, we can make a certain judgment about the value of the public discussions that your claims have created. All of us have learned a great deal about and become more sensitive to the problem of sexual harassment and inappropriate behavior. The issue is complex and our understanding may never be complete, but your perception of your relationship with Judge Thomas is clear in your own mind. And your courage in coming forward and the composure you have demonstrated since this issue became public all speak to your character. I'm sure this has been very painful for you, as it has been for all of us, but I believe that the pain will vastly improve the way that men and women respond to this problem throughout our country. Thank you very much.
Thank you, Mr. Chairman. Professor Hill, you were kind enough to take my call earlier this week and were very forthcoming, and I appreciated that and the information you provided. I had a few additional questions that I thought might be helpful that I would bring up. My impression was that the calls from the staff that had originally prompted you to begin thinking about making a statement included not only questions about sexual harassment, but had actually implied to you that there were rumors circulating about sexual harassment at the EEOC, and even a suggestion that there might be rumors to sexual harassment related to you. Now, could you share your view of what those rumors were or what they had suggested to you in those calls?
Well, when I received the calls, I assumed that someone had known about the incidents as they were occurring, who I did not know, who might have contacted the offices that called me. So when the statements were made and the questions were asked, I assumed that it was someone who knew that these things had happened and that they had come forward to the committee or to the individuals who were calling, and that they were following up on that.
I guess what had occurred to me when I heard that description from you was the, at least inference in my mind, that the fact that there were stories, or there could be stories circulating relating to sexual harassment and perhaps the sexual harassment towards you, that was one of the factors that encouraged you to come forward.
That was definitely one of the factors. I didn't want the committee to rely on rumors. I didn't want the rumors to perhaps circulate through the press without at least considering the possibilities or exploring the possibilities through the committee process of coming forward. So yes, that call, those calls and those raising the issue with me very much encouraged me to further explore the process to determine how and if I could come forward.
You mentioned that you talked to several staffers and then eventually made a decision to come forward, and you chatted with a committee and had a variety of conversations there. Were there others that you talked to after you talked to those two staffers and before you decided to speak to the committee?
I talked with personal friends. I talked with with individuals who knew more about Title VII law than I did.
But I take it none of these conversations included people who were actively opposing the nomination?
No.
When on the employment question, I thought I would go back to it. I must tell you, my own impression is that I think if you have a job, you're reluctant to leave it without some other offers. But I thought it might be helpful to put a cap on that. At the point that Judge Thomas was leaving the Department of Education and had invited you to accompany him or go with him in terms of a job assignment over to the EEOC, did you contact anyone in the private sector for a job? You've already talked about not exploring alternatives within the education department, but did you contact anyone about a job at that point?
I did not contact anyone in the private sector. I had left the private sector 9 months earlier, had decided that I did not want to return at that point to the private sector.
At the point that the harassment, or at least the harassment that took place, that was alleged to take place at the department, education department, did you begin to explore job opportunities at that point? As I understand, that was a point before, sometime before the decision to leave.
No, I did not explore. I may have read government printouts, but I did not actively look for another job.
With regard to the judge himself, you clearly, in working with him as you had, were familiar with a portion of his philosophy. Do you find you were in agreement with his philosophy on most issues, opposed? What can you share with us on that?
Well, I'm not really sure what his philosophy on many issues is, and so I can't say that I'm in agreement or disagreement. I can say that during the times that we worked, there were matters that we agreed on, worked together. There were matters that we agreed on and some that we did not agree on. And we had discussions about those matters. But I'm not really certain what his philosophies are at this point.
Would that be the case with regard to, say, abortion or Roe v. Wade?
That I'm not sure of his philosophies?
Well, sure of his philosophy, or do you perceive a significant difference between the two of you in that area?
Yes.
Can you tell us what that might be? I don't mean to pressure you here. If you would prefer not to, well, please don't. But if there's something you could share with us in that area, I think the committee would like to hear it.
Senator, I don't, on behalf of, from Judge Thomas's position, this was supposed to relate to harassment, not an investigation of Judge Thomas's views on abortion.
Mr. Chairman, you're perfectly correct. I merely, if there was something that wished to be offered there, I thought it would be helpful. I see the red light is on, so I will.
Now, both two of our primary questioners also want to take an additional 5 minutes, or one portion of those. Senator Leahy.
Make it very brief, because everybody is tired and want to go on. Professor Hill, you were asked questions by Senator Simpson regarding this afternoon's FBI investigation, which I believe you were shown. a question of whether there may be some inconsistencies. That's a matter that, I mean, everybody's got to determine whether they feel there is or is not. I make those statements of that, but basically on the thrust that you were less specific about these incidents, the language and the description of these incidents when you talked with the two agents than you were in your statement here today. Let me just 3 or 4 very quick questions. I think you could probably even answer yes or no. The statement you made here today was made under oath. Is that correct?
Yes.
And that statement was more specific than the conversation that you had with the FBI agents. Is that correct?
Yes, I agree.
And when specific questions were asked by different senators about that, you went to even more specific details of the language that you say that Judge Thomas used. Is that correct?
Yes.
And if there had been even more questions going specifically conversation by conversation, it would be safe to say that you would have even more specific language.
I would have attempted to.
It would be safe to say also that you found it uncomfortable repeating even the language that we elicited from you in the questions.
Yes.
Thank you. I have no further questions.
Thank you, Senator Specter.
Thank you, Mr. Chairman. Just a word or two. When you say, Professor Hill, that by hindsight, as I wrote this down, it's difficult for me to understand. And in looking at the entire record, it is difficult for me to understand. You have substantially enlarged the testimony which I had expected based on the FBI report and your statement as to what you allege Judge Thomas had done. The critical move from the Department of Education to EEOC is not understandable to me, where you make the statements about his offensive conduct for an experienced lawyer not to inquire about standing, or even an inexperienced lawyer not to inquire about standing to stay at the Department of Education, or not to make an inquiry of the people in charge. The toll calls you characterized as garbage, which you admitted to in your interview with the newspaper, although you denied other aspects. You now concede to be true that you did make those calls. It is one thing for you to say that you felt constrained to maintain some sort of an association with Judge Thomas in the face of this kind of conduct which you have represented, but why make the calls which you agreed to? The "how are you doing?" or "I'm in town," or "tell the secretary you're in town." Why drive the man to the airport? Why maintain that kind of a cordial association in the face of this kind of conduct? We have an office, Equal Opportunities, EEOC, to enforce the laws on sexual harassment. And we have here representations that the nation's chief law enforcement officer has sexually harassed his attorney advisor. And that attorney advisor is dedicated to enforcement of the law against sexual harassment, and tells us that she moved from the Department of Education to EEOC because she wanted to protect the women of America. And conceding that this is an enormous educational experience, the question is why, with an experienced lawyer in that position, being concerned about women's rights, do you leave a man, Clarence Thomas, as chairman of the EEOC for years, when, according to your testimony, he has been guilty of sexual harassment himself. Now, I do see explanations at every turn, and I have wondered about the quality of those explanations, candidly. But there is no description for this entire proceeding other than a tragedy. I do not know how Judge Thomas defends himself beyond stepping forward and saying that he's shocked, surprised, hurt, and saddened. And the shortest statute of limitations I've ever heard of is 180 days. Until I got involved in this proceeding, I didn't know there was such a short statute of limitations. Contract cases are 6 years, tort cases are 2 years, criminal cases are 5 years, but the federal law has put that into effect because it is so difficult to defend and to go back and to recollect all that has happened. And I appreciate the stark nature of the statements which have been made. But I also see that in your own statement, which you prepared at your leisure, put aside the FBI statement, you were with 2 people, but no mention about the Coke bottle, no mention about sexual prowess, no mention about other major issues which are in your statement. So that I conclude, looking at this very complex day, on our obligation to try to find out what happened between a man and the woman a long time ago when nobody else was there, that I would agree with you, Professor Hill. It's very difficult for me to understand.
Thank you, Senator. Senator from South Carolina, I beg your pardon.
Well, don't forget it.
I realize there's certain things I should never say to the senator from South Carolina, and one of them is that he's from North Carolina.
Mr. Chairman, I just have one brief question. Professor Hill, I understand you told the FBI that you have had concerns about the political philosophy of Judge Thomas and what he may no longer, and that he may no longer be open-minded. Is that accurate?
I told them that I did not quite understand, but as they had been represented, yes, that I did have some concerns.
I have the FBI report here, and I just wonder if you remember telling them that.
I remember a discussion about political philosophy, and I remember specifically saying that I'm not quite sure that we understand his political philosophies, but based on what I understand, yes, there is some discomfort.
That's all.
Thank you. Now, let me just say, Professor Hill, we have heard, in a sense, half of this story today, all of your story, and we have not heard all of Judge Thomas's story. But I, for one, can assure you that, assuming for the moment what you have said is true, there is nothing hard to understand. Having spent as many years as I have dealing with the issue of victimization of women, it is every single psychiatrist and psychologist who considers themselves expert in the field will point out that the nature of response is not at all atypical, assuming it to be true. And please do not be offended by my saying assuming it to be true. I view myself again here as a finder of fact, and we have yet to hear the whole story from Judge Thomas. This is a tragedy. People keep mentioning that. And my good friend from Iowa hopes that this will never happen again in the sense the way the committee handled it. I must be brutally frank with my colleagues and with everyone else involved. I do apologize to the women of America if they got the wrong impression about how seriously I take the issue of sexual harassment. But I make no apologies for attempting to follow every one of your wishes, because every one that I've spoken to, again, in the years that I've dealt with this subject, indicate that the most unfair thing to do to a woman in your position is what was done to you. Force you to do something that you did not intend to do. And so I must tell you, I must tell everyone else, I take sexual harassment seriously, but I take your claim and took your claim that you have reasserted here today a half a dozen times, that you did not want this to go public, as seriously as I possibly could. And for those who suggest that I should not have, or that there was some way to do it differently and still honor your commitment, I know of no such way to guarantee that your anonymity, to guarantee that you would not have to be in this place at this day. I must tell you, every instinct in me in the world wanted to say to the whole Senate and to the whole world that we should have a hearing on this. But again, we tend to look at large issues and forget individuals. You were the individual in the middle of this. And I will say again to anyone who will listen, as long as I am chairman of this committee, if a person comes to me in a similar circumstance and says repeatedly and in different ways that I have no right, I have no authority to tell their story, to leak their story, to demand that their story be put in a context different than they wish, I will honor that commitment. And I appreciate the fact, and to be very, very blunt about it, I can't tell you how thankful I am, purely from a personal standpoint, and I shouldn't say this, but I'm going to say it anyway, that you were so straightforward and honest about the way in which this committee handled your request, and so straightforward and honest about, notwithstanding occasional confusion, how you did not decide to do what is being done here were it not for the fact that it was leaked to a press person. You would not be here today. It seems to me ultimately in this great giant machine we call this nation and this government, that I don't know how we can call ourselves civil libertarians, I don't know how we can call ourselves people interested in the individual, if in the name of a larger cause, to justify the ends, we make a judgment for an individual that that individual chooses and has a right not to make. So I must tell you, I admire you. I admire the way you handled this matter once you were confronted with it. As I said to you very bluntly over the telephone, all of us up here choose to be in this business. We choose to be under these lights. We choose to be under the scrutiny of those ladies and gentlemen sitting behind you. We choose to go before the American public and say, judge me. But we have no right to make you choose to do that. And once you chose to do that because you had no choice, you handled it with such grace and such a lean that I can't quite understand how you were able to pull it off in the sense of walking before all those press people in a press conference and handling the way you did. I don't know 3 candidates in my whole life who could do that, and they've had 27 handlers telling them how to do it. So I don't want to kid anybody. If you came to me again in the same circumstance, and Senator Biden, keep this tight. Do not make it go public. I would do the same thing again. And I thank you for your honesty in laying out just what you did, because you could have very easily said, oh no, I would have come forward no matter what. I was getting ready to do that. And quite frankly, make me look like an idiot and make the whole process look like an idiot. So I thank you very, very much. But most of all, having nothing to do with the process, we can all talk about the process. It's a cumbersome one. But ultimately, it seems to me the purpose of the process is to protect the rights of individuals. I thank you for being willing to be here. I thank you for your testimony. We will now recess. Senator Judge Thomas has indicated, I'll yield just a moment. Judge Thomas has indicated he wants very much to come back on this evening. So we will reconvene this hearing at 9 o'clock and to hear from Judge Thomas. Before we do, I yield to my friend from Alabama who wants to submit to the record some, well, I'll let him say what he wants.
Mr. Chairman, I want to submit certain newspaper articles that have appeared. We will supply to it, but make them for the record. This is from the Washington Post, October the 11th, 1991. The headline is Thomas's View on Harassment, said to evolve. From the Baltimore Sun, dated October the 11th, 91, Thomas Hill disputes. From the New York Times on October the 10th, 1991, stark conflict marks accounts given by Thomas and professors. In the Washington Post, same date, conflict emerges over a second witness. From the Washington Post on October the 11th, 1991, Charlotte woman detailed Thomas's conduct. From the New York Times, October the 7th, 1991, law professor accuses Thomas of sexual harassment in 1980s. And from the U.S. News and World Report, September the 16th, 1991, the article titled The Crowning Thomas Affair.
Without objection, to be placed in the record again, I thank your family. Yes.
I would just like to take this opportunity to thank the committee for its time, its questions, and its effort that is put into this investigation on my behalf. Thank you.
Thank you. Adjourn till 9 o'clock.
Woo! Sorry, I didn't mean to woo on you. It's so loud. But we're going into the next part. I've been waiting for so long for this. You don't understand. This has been like a marathon of trying to get to the bottom of the story here. I wish my wife would come down and hang out with me. She's got the kids. Jacqueline, if you're still watching, can you bring me a sandwich? I know, Mark. I really want to hear Strom Thurmond say murder like Moita, right? He's been charged with this, that, and Moita.
Would you go in and ask somebody because I don't want to start without Thurmond.
Biden doesn't want to start without Thurmond. I don't want to start without Jacqueline. Jacqueline, the number.
Which I think is fair.
64-2.
Like I said, you support me so goddamn much. I never should.
Yeah.
I think that's
super good.
Oren, all right to start. He's sitting there. We would let. Yeah.
Oh, my mic is still on. He's just banging the gavel.
Video,
I got my
please
gavel
come to order.
banked.
Judge, tough day and tough night for you, I know. Let me ask, do you have anything you'd like to say before we begin? And I understand that your preference is, which is totally and completely understandable, that we go 1 hour tonight, 30 minutes on each side. Am I correct in that?
That's right.
Do you have anything you'd like to say?
Senator, I would like to start by saying unequivocally, uncategorically, that I deny each and every single allegation against me today that suggested in any way that I had conversations of a sexual nature or about pornographic material with Anita Hill, that I ever attempted to date her, that I ever had any personal sexual interest in her, or that I in any way ever harassed her. A second, and I think more important point, I think that this today is a travesty. I think that it is disgusting. I think that this hearing should never occur in America. This is a case in which this sleaze, this dirt, was searched for by staffers of members of this committee, was then leaked to the media, and this committee and this body validated it and displayed it at prime time over our entire nation. How would any member on this committee, any person in this room, or any person in this country would like sleaze said about him or her in this fashion, or this dirt dredged up, and this gossip and these lies displayed in this manner? How would any person like it? The Supreme Court is not worth it. No job is worth it. I'm not here for that. I'm here for my name, my family, my life, and my integrity. I think something is dreadfully wrong with this country when any person in this free country would be subjected to this. This is not a closed room. There was an FBI investigation. This is not an opportunity to talk about difficult matters privately or in a closed environment. This is a circus. It's a national disgrace. And from my standpoint, as a black American, as far as I'm concerned, it is a high-tech lynching for uppity blacks who in any way deign to think for themselves, to do for themselves, to have different ideas. And it is a message that unless you kowtow to an old order, this is what will happen to you. You will be lynched, destroyed, caricatured by a committee of the U.S. Senate rather than hung from a tree.
We will have, yes, would you like to say that?
Mr. Chairman,
Senator from South Carolina.
I have named Senator Hatch to cross-examine the judge and then those who are supporting him. So Senator Hatch, you and I take over.
As I understand it, it was, you don't go to...
I think that's correct. I think we would start with,
yes,
with Senator Heflin and then go to Senator Hatch,
sure,
if that's appropriate.
Sure, I think that's the way I was... I'd be happy to do it, but I think that's the way I was told.
Senator Heflin.
Judge Thomas, in addition to Anita Hill, there have surfaced some other allegations against you. One was on a television show last evening here in Washington, Channel 7. I don't know whether you saw that or not. You didn't see it. It was carried somewhat in the media, print media today, but it involved a man by the name of Earl Harper, Jr., who allegedly was a senior trial lawyer with the EEOC at Baltimore in and around the early 80s. Do you recall this instance? pertaining to Earl Harper, Jr.?
I remember the name. I can't remember the details.
The allegations against Mr. Harper involved some 12 or 13 women who claim that Mr. Harper made unwelcome sexual advances to several women on his staff, including instances in which Mr. Harper masturbated in the presence of some of the female employees. The allegations contain other aspects of sexual activity. The information we have is that the General Counsel of the EEOC, David Slate, made a lengthy internal investigation and found that this had the effect of creating an intimidating, hostile, and offensive working environment. And that on November the 23rd, 1983, you wrote Mr. Slate a memo urging that Mr. Harper be fired. Mr. Slate eventually recommended dismissal. Then the story recites that you did not dismiss him, that you allowed him to stay on for 11 months, and then he retired. Does that bring back to you any recollection of that event concerning Mr. Earl Harper, Jr.?
Again, I'm operating strictly on recollection. If I remember the case, if it's the one I'm thinking of, Mr. Harper's supervisor recommended either suspension or some form of sanction or punishment that was less than termination. When that proposal, his supervisor initially was not David Slate, when that proposal reached my desk, I believe my recommendation was that for the conduct involved, he should be fired. The problem there was that if the immediate supervisor's decision is changed, and I believe Mr. Harper was a veteran, there are a number of procedural protections that he had, including a hearing, and of course he had a lawyer, and there was potential litigation, et cetera. I don't remember all of the details, but it's not as simple as you set it out. It was as a result of my insistence that the General Counsel, as I remember, upgraded the sanction to termination.
Do you know a congressman by the name of Scott Klug, a Republican congressman who was defeated Robert Kastenmeier from Wisconsin, who now serves in Congress, who back in the early 80s, 83 or something, was a television reporter for a channel here in Washington, and that he, at that time, disclosed this as indicating that after the recommendation of dismissal, that you did not move in regards to it for some 11 months and let him retire. Do you know Congressman Klug?
I do not know him. Again, I remember I'm operating on recollection. There was far more to it than the facts as you set them out. His rights had much to do with the fact that he was a veteran and that we could not simply dismiss him. If we could, that was my recommendation, he would have been dismissed.
There was no political influence brought to bear on you at that time to prevent his dismissal. Do you recall if any political influence?
Absolutely no political influence. In fact, it was my policy that no personnel decisions would in any way be changed or influenced by political pressure, one way or the other.
Now, it's reported to me that Congressman Klug, after your nomination, went to the White House and told this story, and that I hear by hearsay that the White House ignored his statement, that Congressman Klug further came to the Senate Judiciary Committee and made it known here, and that as far as I know, I attempted to check, I hadn't been able to find where it was in the Judiciary Committee, if it was, and I think the chairman has attempted to locate. But the point I'm asking is, in your process pertaining to the nomination and the preparation for it, were you ever notified that Congressman Klug went to the White House in regards to this?
I don't remember that, Senator.
Nobody ever discussed that with
No.
you? Well, that's the way it's been reported to me, and it's very fragmented and relative to it, but I have asked that all the records of the EEOC be subpoenaed by subpoena ducis tecum pertaining to that, in order that we might get to the bottom of it.
Interrupt Senator Heflin. I really think this is outside the scope, under the rules. I would have to object to.
I would have to sustain that objection. I do not.
I hesitate to object. I just think you keep it on the subject matter.
I do not see where it's relevant.
Well, I think it is relevant in the issue pertaining to period of time relative to the issue, and particularly in regards to the responsibilities as head of an agency dealing with discrimination in employment.
If I may say, let me speak. If I may say, this is not about whether or not the judge administered properly or improperly the agency. The only issue here relates to conduct and the allegations that have been made. So I would respectfully suggest to my friend from Alabama that line of question is not in order, and I rule it out of order.
All right, sir. I'll reserve an exception, as we used to say. Now, you, I suppose, have heard Professor Hill, Ms. Hill, Anita F. Hill, testify today.
No, I haven't.
You didn't listen?
No, I didn't. I've heard enough lies.
You didn't listen to her testimony?
No,
at
I
all?
didn't.
On television?
No, I didn't. I've heard enough lies. The day is not a day that, in my opinion, is high among the days in our country. This is a travesty. Taken me 43 years to build, and providing a forum for that.
Well, Judge Thomas, You know, we have a responsibility too. And
What's a
as
hamster?
far as
I
I'm
gotta go back into the chat.
involved, I had nothing to do with Anita Hill coming here and testifying. We're trying to get to the bottom of this, and if she is lying, then I think you can help us prove that she was lying.
Senator, I am incapable of proving the negative. It did not occur.
Well, if it did not occur, I think you are in a position with certainly your ability to testify to, in effect, to try to eliminate it from people's minds.
Senator, I didn't create it in people's minds. This matter was investigated by the Federal Bureau of Investigation in a confidential way. It was then leaked last weekend to the media. I did not do that. And how many members of this committee would like to have the same scurrilous, uncorroborated allegations made about him and then leaked to national newspapers and then be drawn and dragged before a national forum of this nature to discuss those allegations that should have been resolved in a confidential way?
Well, I certainly appreciate your attitude towards leaks. I happen to serve on the Senate Ethics Committee, and it's been a sieve.
Well, but it didn't leak on me. This leaked on me, and it is drowning my life, my career, and my integrity. And you can't give it back to me, and this committee can't give it back to me, and this Senate can't give it back to me. You have robbed me of something that can never be restored.
I know exactly how you feel.
Judge Thomas, one of the aspects of this is that she could be living in a fantasy world. I don't know. We're just trying to get to the bottom of all of these facts. But if you didn't and didn't testify, I think you put yourself in an unusual position. You, in effect, are defending yourself. And basically, some of us want to be fair to you, fair to her. But if you didn't listen to what she said today, then that puts it somewhat in a more difficult task to find out what the actual facts are relative to this matter.
The facts keep changing, Senator. When the FBI visited me, the statements to this committee and the questions were one thing. The FBI's subsequent questions were another thing. And the statements today, as I received summaries of them, were another thing. It is not my fault that the facts change. What I have said to you is categorical, that any allegations that I engage in any conduct involving sexual activity, pornographic movies, attempted to date her, any allegations, I deny. It is not true. So the facts can change, but my denial does not. Ms. Hill was treated in a way that all my special assistants were treated. Cordial, professional, respectful.
Judge, if you're on the bench and you approach a case where you appear to have a closed mind and that you are only right, doesn't it raise issues of judicial temperament?
Senator, there is a big difference between approaching a case objectively and watching yourself being lynched. There is no comparison whatsoever.
He has personal knowledge of this as well, and personal justification for anger.
Judge, I don't want to go over this stuff, but of course there are many instances in which she has stated, but and in effect, since you didn't see her testify, I think it's somewhat unfair to ask you specifically about it. I would reserve my time and go ahead and let Senator Hatch ask you and then come back.
Senator Hatch.
Okay. Judge Thomas, I've sat here and I've listened all day long. And Anita Hill was very impressive. She's an impressive law professor. She's a Yale Law graduate. And when she met with the FBI, she said that you told her about your sexual experiences and preferences. And I hate to go into this, but I want to go into it because I have to. And I know it's something that you wish you'd never heard at any time or place. But I think it's important that we go into it. And let me just do it this way. She said to the FBI that you told her about your sexual experiences and preferences, that you asked her what she liked, or if she had ever done the same thing, that you discussed oral sex between men and women, that you discussed viewing films of people having sex with each other and with animals, and that you told her that she should see such films, and that you like to discuss specific sex acts and the frequency of sex. What about that?
Senator, I would not want to accept being required to here to dignify those allegations with a response. As I said before, I categorically deny them. To me, I have been pilloried with scurrilous allegations of this nature. I have denied them earlier, and I deny them tonight.
Judge Thomas, today, in a new statement, in addition to what she told the FBI, which I have to agree with you is quite a bit, she made a number of other allegations. And what I'd like to do is, some of them most specific were for the first time today in addition to these, which I think almost anybody would say are terrible. Now, I'd just like to give you an opportunity, because this is your chance to address her testimony. At any time, did you say to Professor Hill that she could ruin your career if she talked about sexual comments you allegedly made to her?
No.
Did you say to her in words or substance that you could ruin her career?
No.
Should she ever have been afraid of you and any kind of vindictiveness to ruin her career?
Senator, I have made it my business to help my special assistants. I recommended Ms. Hill for her position at Oral Roberts University. I've always spoken highly of her. I had no reason prior to the FBI visiting me a little more than 2 weeks ago to know that she harbored any ill feelings toward me or any discomfort with me. This is all new to me.
It's new to me too, because I read the FBI report at least 10 or 15 times. I didn't see any of these allegations I'm about to go into, including that one. But she seemed to sure have a recollection here today. Now, did you ever say to Professor Hill in words or substance, and this is embarrassing for me to say in public, but it has to be done, and I'm sure it's not pleasing to you. Did you ever say in words or substance something like, there is a pubic hair in my Coke?
No, Senator.
Did you ever refer to your private parts in conversations with Professor Hill?
Absolutely not, Senator.
Did you ever brag to Professor Hill about your sexual prowess?
No, Senator.
Did you ever use the term long dong silver in conversation with Professor Hill? Had you?
No, Senator.
Did you ever have lunch with Professor Hill at which you talked about sex or pressured her to go out with you?
Absolutely not.
Did you
I
ever
have
tell
had no such discussions, nor have I ever pressured or asked her to go out with me beyond her work environment.
Did you ever tell Professor Hill that she should see pornographic films?
Absolutely not.
Did you ever talk about pornography with Professor Hill?
I did not discuss any pornographic material or pornographic preferences or pornographic films with Professor Hill.
So you never even talked or described pornographic materials with her?
Absolutely not.
Well, most of those are in addition.
What I have told you is precisely what I told the FBI on September 25th when they shocked me with the allegations made by Anita Hill.
Judge Thomas, those were a lot of allegations. Those were a lot of charges, talking about sexual experiences and preferences, whether she liked or had ever done the same thing, oral sex, viewing films of people having sex with each other and with animals, that maybe she should see such films, discuss specific sex acts, talk about pubic hair and coke, talking about your private parts, bragging about sexual prowess, talking about particular pornographic movies. Let me ask you something. You have dealt with these problems for a long time. At one time I was the chairman overviewing the EOC, and I might add the Department of Education. Now I'm the ranking member today, and I've known you for 11 years. And you're an expert because you're the person who made the arguments to the then Solicitor General Freed that the administration should strongly take a position on sexual harassment cases in the Meritor Savings Bank v. Vinson case. And the Supreme Court adopted your position. Did I misstate that?
Senator, what you've said is substantially accurate. What I attempted to do in my discussions with the solicitor is to have them be aggressive in that litigation, and the EEOC was very instrumental in the success in the Meritor case.
Now, Judge, keep in mind that the statute of limitations under Title VII for sexual harassment for private employers is 180 days or 6 months. But the statute of limitations under Title VII for federal employers and employees is 30 days. Are you aware of that?
Yes, Senator, I'm generally aware of those limitations.
And are you aware of why those statutes of limitation are so short?
I would suspect that at some point it would have to do with the decision by this body that either memories begin to fade or stories change, perhaps individuals move around, and it would be more difficult to litigate them. I don't know precisely what all of the rationale is.
Well, it involves the basic issue of fairness, just exactly how you have described it. If somebody is going to be accused in a unilateral declaration of sexual harassment, then that somebody ought to be accused through either a complaint or some sort of a criticism so that that somebody can be informed and then respond to those charges, and if necessary, change that somebody's conduct. Is that a fair statement?
I think that's fair, Senator.
Now let me ask you something. I described all kinds of what I consider to be gross, awful, sexually harassing things, which, if you take them in cumulation, have to gag anybody. Now, you've seen a lot of these sexual harassment cases as you've served there at the EEOC. What is your opinion with regard to what should have been done with those charges, and whether or not you believe that, let's take Professor Hill in this case, should have done something, since she was a Yale Law graduate who taught civil rights law at one point, served in these various agencies, and had to understand that there's an issue of fairness here?
Senator, if any of those activities occurred, it would seem to me to clearly suggest or to clearly indicate sexual harassment. And anyone who felt that she was harassed could go to an EEO officer at any agency and have that dealt with confidentially. At the Department of Education, if she said it occurred there, or at EEOC. Those are separate tracks at EEOC. I do not get to review those if they involve me. And at the Department of Education, there's a separate EEO officer for the whole department. It would have nothing to do with me. But if I were an individual advising a person who'd been subjected to that treatment, I would advise her to immediately go to the EEO officer.
And the EEO office then would bring the parties together, or at least would confront the problem head on, wouldn't it?
The EEO officer would provide counseling.
Within a short period of time?
Within a short period of time, as well as, I think, if necessary, an actual charge.
So the charge would be made, and the charge would then, the person against whom it was made would have a chance to answer it right then, right up front, in a way that could resolve it and stop this type of activity if it ever really occurred.
That's right.
And you've just said it never really occurred.
It never occurred. That's why there was no charge.
See, one of the problems that has bothered me from the front of this thing is these are gross, accumulated. I don't know why anybody would put up with them, or why anybody would respect or work with another person who would do that. And if you did that, I don't know why anybody would work with you who suffered these treatments. Furthermore, I don't know why they would have gone to a different position with you. Even if they did think that maybe it had stopped and it won't start again, but then claimed that it started again. And then when they finally got out into the private sector, wouldn't somehow or other confront these problems in 3 successive confirmation proceedings. Does that bother you?
This whole affair bothers me, Senator. I am witnessing the destruction of my integrity.
And it's by a unilateral set of declarations that are made on successive dates and differ.
That's
by
true.
One person who continued to maintain what she considered to be a, quote, cordial, professional relationship with you over a 10-year period.
Senator, my relationship with Anita Hill prior to September 25th was cordial and professional. And I might add one other thing. If you really want an idea of how I treated women, then ask the majority of the women who worked for me. They're out here. Give them as much time as you have given one person, the only person who's been on my staff who's ever made these sorts of allegations about me.
Well, I think one of our senators, one of our better senators in the United States Senate, did do exactly that. And he's a Democrat. As a matter of fact, one of the fairest people, and I think one of the best new people in the whole Senate. This is a statement that was made on the floor of the Senate in this record by my distinguished colleague, Senator Lieberman, man I have a great deal of respect for. Senator Lieberman's staff conducted a survey of various women who have worked for you over the years. He was concerned. He's been a supporter of yours. And he was one who asked for this delay so that this could be looked into because he was concerned too. But as a result of the survey, Senator Lieberman made the following statement. He said, I have contacted associates, women who worked with Judge Thomas during his time at the Department of Education and EOC, and in the calls that I and my staff have made, there has been universal support for Judge Thomas and a clear indication by all of the women we spoke to that there was never, certainly not, a case of sexual harassment and not even a hint of impropriety. That was put into the congressional record on October 8, 1991. And I think Senator Lieberman has performed a very valuable service because he's in the other party. He's a person who looks at these matters seriously. He has to be as appalled by this type of accusation as I am. And frankly, he wanted to know just what kind of a guy is Clarence Thomas. And those of us who know you know that all of these are inconsistent with the real Clarence Thomas. And I don't care who testifies, you have to keep in mind this is an attorney, law graduate from one of the 4 or 5 best law schools in this land, very intelligent, articulate law professor, and the only person on earth other than you knowing whether these things are true. The only other person. I don't blame you for being mad.
Senator, I have worked with hundreds of women in different capacities. I have promoted and mentored dozens. I will put my record against any member of this committee in promoting and mentoring women.
I will put your record against anybody in the whole Congress.
And I think that if you want to really be fair, you parade every single one before you, and you ask them in their relationships with me whether or not any of this nonsense, this garbage, trash that you siphoned out of the sewers against me, whether any of it is true. Ask them. They've worked with me. Ask my chief of staff, my former chief of staff. She worked shoulder to shoulder with me.
Well, I think we should do that. Now, Judge, what was Professor Hill's role in your office at the Education Department and at the EEOC?
Senator, as I indicated this morning, at the Department of Education, Ms. Hill was an attorney advisor. I had a small staff, and she had the opportunity to work on a variety of issues.
She was your number one person?
She, by and large, on substantive issues, she was.
How about when you went to the EEOC?
At EEOC, that role changed drastically. As I indicated, my duties expanded immensely. EEOC, as you remember, had enormous management problems, so I focused on that. I also needed an experienced EEO staff, and my staff was much more mature. It was older. It was a more experienced staff. As a result, she did not enjoy that close a relationship with me, nor did she have her choice of the better assignments. And I think that as a result of that, there was some concern on her part that she was not being treated as well as she had been treated prior to that.
At any time in your tenure in the Department of Education, did Professor Hill ever express any concern about or discomfort with your conduct towards her?
No.
Never?
No. The only caveat I would add to that would be that from time to time people want promotions or better assignments or work hours, something of that nature, but no discomfort of the nature that is being discussed here today.
Now, I note that Professor Hill alleges improper conduct on your part during the period of November 1981 to February or March of 1982. Now, isn't it true that both you and Professor Hill moved from the Education Department to the EEOC in April of that same year?
Senator, that's an odd period. The President expressed his intent to nominate me to become chairman of EEOC in February of 1982. And during that very same period, to the best of my recollection, she assisted me in my nomination and confirmation process. And I did, in fact, leave actual work at the Department of Education, I believe in April, and started at EEOC in May of 1982, and she transferred with me.
So in other words, Professor Hill followed you to the EEOC no more than 2 or 3 months, possibly only 1 month after she claims this alleged conduct occurred.
Precisely.
Isn't it true, Judge Thomas, that Professor Hill could have remained in her job at the Education Department when you went to the EEOC?
To the best of my recollection, she was a Schedule A attorney. I know she was not cleared through the White House, so she was not a Schedule C. She was not a political appointee. As a result, she had all the rights of Schedule A attorneys and could have remained at the Department of Education in a career capacity.
And even if she might not have remained the #1 person to the head of the Civil Rights Division, which you were, she would have been transferred to another equivalent attorney's position.
If she had requested.
Did you tell her anything to the contrary?
Not to my knowledge. In fact, I don't think it ever came up.
She didn't even ask you?
I don't think it ever came up. I think it was understood that she would move to EEOC with me if she so desired.
I think just button it down. In other words, Judge Thomas, if instead of following you to the EEOC, Professor Hill had remained at the Department of Education as a Schedule A attorney, she would have had as much job security as any other civil service attorney in the government. And this is especially true, isn't it, because of your friendship with Harry Singleton?
That's right. If she was concerned about job security, I could have certainly discussed with Harry Singleton what should be done with him. He's a personal friend of mine. He's also, or was a personal friend of the individual who recommended Anita Hill to me, Gil Hardy. Gil Hardy, of course, drowned in 1988. But both of us, or all three of us, had gone to Yale Law School and knew each other quite well.
Now, Judge Thomas, I understand that on occasion, and you correct me if this is wrong, but I've been led to believe that on occasion, Professor Hill would ask you to drive her home, and that on those occasions she would sometimes invite you into her home to continue a discussion. But you never thought of anything, you never thought of any of this as anything but a more than normal, friendly or professional conversation with a colleague. Am I correct on that, or am I wrong?
It was not unusual to me, Senator. As I remember it, I lived in Southwest Washington and would, as I remember, and again, I'm relying on my recollection, she lived someplace on Capitol Hill, and I would drive her home and sometimes stop in and have a Coke or a beer or something and continue arguing about politics for maybe 45 minutes to an hour. But I never thought anything of it.
When Professor Hill worked for you at the EEOC, did she solicit your advice on career development or career opportunities?
Senator, as I discuss with most of the members of my personal staff, I try to advise them on their career opportunities and what they should do next. You can't always be a special assistant or an attorney advisor. And I am certain that I had those discussions with her. And in fact, it would probably have been based on that I advised Dean Cothe that she would be a good teacher and that she would be interested in teaching.
Did she treat you as as her mentor at the time, in your opinion?
Pardon me?
Did she treat you as though you were a mentor at the time?
She certainly sought counsel and advice from me.
Now, at any time during your tenure at the EEOC, did you ever discuss sexual matters with Professor Hill?
Absolutely not, Senator.
At any time during your tenure at the EEOC, did Professor Hill ever express discomfort or concern about your conduct towards her?
No, Senator.
From your observations, what was the perception of Professor Hill by her colleagues at the EEOC? What did they think about her?
Senator, some of my former staffers, I assume, will testify here, but as I remember it, there was some tension and some degree of friction, which I attributed simply to having a staff. As I've had 2 weeks to think about this and to agonize over this, and as I remember it, I believe that she was considered to be somewhat distant and perhaps aloof, and from time to time there would be problems that usually involved, and I attributed this to just being young, but usually involved her taking a firm position and being unyielding to the other members of the staff, and then storming off or throwing a temper tantrum of some sort that either myself or the Chief of Staff would have to iron out.
What was your opinion of the quality of Professor Hill's work at the EEOC as her administrator and as the head of the EEOC?
I thought the work was good. The problem was and it wasn't a problem, it was not as good as some of the other members of the staff.
While Professor Hill worked for you at the EEOC, did she ever seek a promotion?
I believe she did seek promotions. Again, most of that was done through the Chief of Staff at that time.
Well, if so, to what position?
She may have sought a promotion. In 1983, my Chief of Staff left, and I was going to promote someone to my executive assistant / Chief of Staff, which is the most senior person on my personal staff. And I think that, and again, I'm relying on my memory, she aspired to that position and, of course, was not successful, and I think was concerned about that.
I see. When did Professor Hill leave the Equal Employment Opportunity Commission?
In '83.
In '83. Why do you think she decided to leave the agency at that time?
Senator, I thought that she felt that at the time that it was time for her to leave Washington and also to leave government. And she had, I believe, expressed an interest in teaching, and the opportunity at Oral Roberts University provided her both with the opportunity to be in Oklahoma and to teach. And as I remember, she did not lose any salary or any income in the bargain, that was attractive.
Excuse me, did you assist her in getting that job at Oral Roberts University?
Yes, Senator. I discussed her with Dean Charles Cothe, both informally and provided written recommendation, formal recommendation for her.
All right. Have you had any contacts with Professor Hill since she left the EEOC in 1983?
Senator, from time to time, Anita Hill would call the agency and either speak to me or to my secretary, and through her she would leave messages. They had been friends, Diane Holt. And on a number of occasions, I believe two, I'm certain of one, but maybe two, when I was in Tulsa, Oklahoma, I spent time with her. I saw her, and I believe on one occasion she drove me to the airport and had breakfast with me.
Mr. Chairman, with unanimous consent, I would introduce into the record at this point excerpts from Judge Thomas's telephone logs from 1983 to 1991, if I could.
Without objection.
Now, Judge Thomas, could you take a copy of these? Do you have a
They
copy
are
of
the
these?
same excerpts that we have had.
These are the
Senator
same ones that
Danforth.
you have had. Now, Judge Thomas, are you familiar with these?
I have seen those logs, Senator.
Okay. Do you recall any of the telephone conversations with Professor Hill reflected by these particular messages?
I do, Senator.
For instance, on January 31st, according to these logs, and I think I've got them correct, I'm quite sure. On January 31st, 1984, at 11:30 a.m., a message from Anita Hill, quote, "Just called to say hello. Sorry she didn't get to see you last week," unquote. Is that accurate?
Yes, that was, I think, one instance when she had come to town either on personal business or because of her job, and my schedule conflicted with her, with any opportunity to meet with her, and simply that was a call from her, I think, to reflect that.
Okay, number two, on May 9th, 1984 at 11:40 a.m., Anita Hill was the caller. The message was, "Please call." And she left her phone number, 718, etc. Do you remember that?
Yes, Senator.
Number three, on August 29th, 1984 at 3:59 p.m., Anita called, and the message was, quote, "Needs your advice in getting research grants," unquote. Do you recall that?
I remember that,
What was
Senator.
that all about?
I can't remember exactly what the project was, but she wanted some ideas as to how she could get I think, some grants either from EEOC or some other agency to do some research, I believe, at Oral Roberts. And I believe we discussed that, and I may have put her in contact with someone. My recollection of that is vague, but we did have a discussion.
Did you help her?
I tried.
You tried. Number 4, on August 30th, 1984 at 11:55 a.m., Anita was the caller. Message, returns your call. Call between 1 and 4. You remember that?
I don't remember the specifics of the call, but I remember that on the log, Senator.
Was she calling you, or were you calling her?
She was calling me. My secretary, when I placed a call and someone returned it, my secretary noted, returned your call.
Okay, on January 3rd, 1985 at 3:40 p.m., Anita Hill was the caller. Quote, please call tonight, and then left a phone number and a room number. Do you remember that?
I remember that. I think she must have been in town on a trip, and that was her hotel room number. I don't know which hotel. And I, again, may have been out of town on either a business trip or somehow, for some other reason, inaccessible or unavailable.
Number 6, February 26, 1985, 5:50 p.m. Anita Hill was the caller. Again, it said, please call. Another call from her to you?
That's right.
Number 7, on March 4th, 1985 at 11:15 a.m., Anita Hill called again, quote, please call Ray Research Project, unquote. You remember that?
I remember that, Senator.
Did you help her?
We did. I think I can't remember the details, but I think she and Dean Charles Cothe were involved in some research, a fairly large project, and wanted some data from EEOC, and I think we provided them with that data.
Number 8, March 4th, 1985, 11:25 a.m., call from Susan Cahill. Quote, with Tulsa EEO office referred by Anita to see if you would come to Tulsa on 3/27 to speak at the EEO conference, unquote. You remember that?
Yes, I remember the message. I think that was, she would not otherwise have gotten through to me and used Anita's name in order to gain access to me and perhaps receive a positive response.
Mr. Chairman, I know my time's just about up, but I just want to finish this one line if I can.
You have all the time you want.
All right, thanks. I really appreciate that. Number 9. Number 9 is July 5th, 1985 at 1:30 p.m. Anita Hill, the caller. Please call, with a number clearly out of town. Remember that?
Again, I remember reviewing my log, Senator.
Okay, number 10. October 8th, 1986, 12:25 p.m. Anita Hill called, message, please call, leaving a 405 area code number. Remember that?
Yes, Senator.
Number 11, August 4th, 1987, 4 o'clock p.m., Anita Hill caller. Quote, in town till 8:15, wanted to congratulate you on your marriage, unquote. Do you remember that?
I remember that, Senator, because one of the my wife and I were on a delayed honeymoon in California when she came to town.
Number 12, November 1st, 1990, 11:40 a.m. Anita Hill, caller, Ray speaking engagement at University of Oklahoma School of Law. Remember that?
That was since I've been on the Court of Appeals, Senator.
There were 12 phone calls between 1983 and 1990. Did you try to call her back each time?
Senator, I try to, whenever I received calls from her or from others, I attempted to return those calls. Although, as I indicated before you started through those series of calls, I remember the messages in the log themselves. I don't remember the nature of each call. It would be my practice to return those calls, especially from someone such as Anita.
So each and every time she called, you tried to call her back and tried to help her?
Senator, that is, the log reflects only those calls where she was unsuccessful in reaching me.
Did you ever call her other than to return these calls?
Senator, I may have. Anita Hill was someone that I respected and was cordial toward and felt positive toward and hopeful for her career. And I may have, on occasion, and I can't remember any specific occasion, picked up the phone just to see how she was doing. But again, the calls that you have there are the calls that are reflected or that reflect her inability to get in touch with me when she had called, as opposed to the instances in which she was able to contact me successfully.
Judge Thomas, before this day, have you seen Professor Hill on various occasions since she left the Equal Employment Opportunity Commission?
Yes, Senator. As I indicated, I recall seeing her, I'm certain of one time and perhaps twice, in Tulsa, Oklahoma. And on one of those occasions, it is my recollection that we had dinner with Charles Cothe. We also had Charles Cothe, the dean of.
But was she there at that dinner?
She was at the dinner. We also had, we being Anita and myself, breakfast with Charles Cothe at his house. I usually slept at Charles Cothe's house, and I believe she drove me to the airport. And for some reason, I seem to remember that she had a Peugeot. I could be wrong on that. But I remember her being very proud of it because, to my recollection, she did not have a car in Washington.
I see. These, in addition to all the phone calls, you had these contacts and these meetings. How would you describe these meetings?
Very cordial, positive, always one. It's, as I treat my other special assistants, I tend to be the proud father type who sees his special assistants go on and become successful and feels pretty good about it. It would be that kind of a contact, as well as her telling me how her teaching assignments were going. Indeed, that was similar to the conversation, again, that I would have with my other special assistants, or former special assistants.
Overall, how would you characterize the nature of your contacts with Professor Hill since she left the EEOC in 1983?
They've been always very cordial and very positive, Senator.
Any unpleasantness?
Never.
Any problems ever raised?
No, Senator.
Any questions about your conduct?
No, Senator.
Can you think of any reason for her efforts to continue to try to be associated with you?
Senator, could you repeat the question, Senator?
Well, can you think of any real reason why she would want to continue these cordial professional relationship with you, or this cordial professional relationship with you?
Senator, I would hope it would have been for the same reasons that all of my other special assistants did, that I was very supportive of them. The people that, some of whom you will hear from today, who've flown in, certainly at their own expense, they feel warmly toward me and have a sense of loyalty, and feel that I will help them and that I will assist them as best I could. And I believe that that was a part of the reason, and we certainly enjoyed a cordial and professional relationship.
Well, before you first heard of Professor Hill's allegations during this confirmation process, did you have any reason to believe that she was unhappy with you?
Senator, on Tuesday, on September 24th, the day before I heard from the FBI, I would have told you, if you asked me, that my relationship with Anita Hill was cordial, professional, and that I was very proud of her for all she'd done with her life and the things that she had accomplished.
Judge Thomas, this is your fourth confirmation in 9 years, isn't that correct?
Yes, Senator. It's either my... Yes, Senator, it is.
In fact, 3 of those confirmations occurred, I guess they were after, including this one, occurred after these allegations, at the time of the allegations by Professor Hill.
Actually, this, Senator, would be the 4th on the...
That's right, isn't it? It would be
this
the 4th.
would be the 4th.
So she She actually has known you through 4 Senate confirmations. 4 of them.
This is the 5th.
No, this is the 4th. Through 4 Senate confirmations, right?
That's right.
And none of those have been very easy, have they?
That's right. Now that I think about it, none of my confirmations, aside from the first one, was easy.
And you had your critics in each and every one of them, didn't you?
That's right.
Do you remember the details of each of those calls that were made that we went over? Or do you just remember them generally?
I remember the calls generally, Senator. I don't remember the specifics of each call. That's been quite some time.
Well, let me just say this. I've kept everybody too long, and I know we can continue tomorrow. But I'd like to ask this question just to end the day with, and I think it's an important question. I have to say, cumulatively, these charges, even though they were made on all kinds of occasions, I mean, they're unbelievable that anybody could be that perverted. I'm sure there are people like that, but they're generally in insane asylums. What was your reaction when you first heard of these allegations against you? Just the first allegations, not all these other ones. And then you can tell me your reaction when you've heard of these ones that were brought forth the first time today.
Senator, when the FBI informed me of the allegation, the person first, there was shock, dismay, hurt, pain, and when he informed me of the nature of the allegations, I was surprised, it was disbelief, and again hurt, and I have reached a point over the last 2 weeks plus, I've reached a point that I can't go over each and every one of these allegations again. As I said in my statement this morning, that when you have allegations of this nature by someone that you have thought the world of and felt that you've done the best for, it is an enormously painful experience. And it is one when you ask yourself, you rip at yourself, what could you have done? And why could this happen? Or why would it happen?
How do you feel right now, Judge, after what you've been through?
Senator, as I indicated this morning, it just isn't worth it. The nomination isn't worth it. Being on the Supreme Court isn't worth it. There is no amount of money that's worth it. There's no amount of money that can restore my name. Being an Associate Justice of the Supreme Court will never replace what I've been robbed of. And I wouldn't recommend that anyone go through it. And this has been an enormously difficult experience, but I don't think that that's the worst of it. I'm 43 years old, and if I'm not confirmed, I'm still the youngest member of the U.S. Court of Appeals for the D.C. Circuit. I'll go on. I'll go back to my life of talking to my neighbors and cutting my grass and getting a Big Mac at McDonald's and driving my car, seeing my kid play football. I'll live. I'll have my life back. And all this hurt has brought my family and I closer, my wife and I, my mother. But that isn't, so there's no pity for me. I think the country has been hurt by this process. I think we are destroying our country, we are destroying our institutions, and I think it's a sad day when the U.S. Senate can be used by interest groups and hate mongers and people who are interested in digging up dirt to destroy other people and who will stop at no tactics when they can use our great institutions for their own political ends. We are gone far beyond McCarthyism. This is far more dangerous than McCarthyism. At least McCarthy was elected.
Judge, I have a lot of other questions to ask you, and I think they're important questions. And I think you deserve the opportunity to tell your side of this. And you've done it here so far. And I have to tell you, this has come down to this. One woman's allegations that are 10 years old against your lifetime of service over that same 10-year period. Now, I've known you almost 11 years. And the person that the good professor described is not the person I've known. And we're going to talk a little bit more about this tomorrow and about what went on there and about how this could have happened, how one person's allegations, uncorroborated, nobody else, it's all private, according to her, could tend to destroy a career and one of the most wonderful opportunities for a young man from Pinpoint, Georgia. Something that I think has lifted almost everybody up till these allegations were unfairly disclosed by someone on this committee and or their staff, maybe on this committee. And Mr. Chair.
I repeat what I said. I have been hurt by this deeply, and nothing is worth going through this. This has devastated me. It's devastated my family. It's untrue. They're lies. I have hundreds of women who work with me. You can call them. Dozens who worked closely with me on my personal staff. You can call them. You can bring them up, give them as much airtime as you've given this one person with uncorroborated, scurrilous lies and allegations. Give them as much time. See what they say.
Well,
but it's not just that, Senator. It's more that's happened. You are ruining the country. If it can happen to me, it can happen to anybody, anytime, over any issue. Our institutions are being controlled by people who will stop at nothing. They went around this country looking for dirt, not information on Clarence Thomas, dirt. Anybody with any dirt, anything, late night calls, calls at work, calls at home, badgering, anything, give us some dirt. I think that if our country has reached this point, we're in trouble, and you should feel worse for the country than you do for me.
I feel bad for both. Mr. Chairman, I'm sorry I've kept us over a little bit. I wish I could proceed even further tonight, but I think we'll wait till tomorrow morning. I know everybody's dead tired, and I'm sure you're dead tired. I know that. So, Mr. Chairman, thank you for giving me this extra time. You've always been courteous and decent, and frankly, you've run this committee through this whole process in a courteous and decent way, including you ran it right with regard to the FBI report as well. And we on this side know that, so thank you.
Let me, before we go, Judge Heflin reserved
just
some of his time.
One or two questions now. Judge Thomas, you described Anita Hill and your relationship with her up until you heard on September, I believe you said 24th. It's cordial, positive, had no trouble with her. in any way. Now, you make rather strong statements. Do you think that Anita Hill is lying?
Senator, I know that what she's saying is untrue.
Now, what do you think that her motivations are to come here and testify?
Senator, I have agonized over that. I've thought about it. I've thought about why she would say these things, why she would come here, why it would keep changing. I don't know.
Well, if you don't know, you see, we in the committee have a responsibility to figure out if she's not telling the truth, why? Is when you worked with her, did you feel that she was a zealous civil rights supporter who was willing to consider and be only a one-interest individual?
Senator, I cannot characterize her that way. I've not thought about her that way. But I would like to address what you said before that. I think you have more than an obligation to figure out why she would say that. I think you have an obligation to determine why you would allow uncorroborated, unsubstantiated allegations to ruin my life.
And this happens sometimes. Just this audio just drops. On C-SPAN, what are we doing here?
She has testified. You, in effect, act as a character witness for her. You have testified here about the relationship, her work, and her reputation. And here we are trying to get to the bottom of it, is what the facts are. And we want to know what the truth is. You knew her probably better than any one of us.
Senator, there are others that you could bring as witnesses. I have suggested to you there are dozens of people who work there.
Well, I think you've made a point, and I hope that they are brought here.
We are. We've agreed already.
But we still faced with the fact, Judge, that if she's lying, why?
Senator,
we are still faced with the fact, if she's telling a falsehood, what is the motivation? Now, we've watched her testify today, and she's a meek woman.
that is not as I remember Anita. Anita is, I can say that, and you can ask others who visit here, Anita would not have been considered a meek woman. She was an aggressive debater. She stood her ground. When she got her dander up, she would storm off. I would say that she was a bright person, a capable person. Meek is not something, a characterization that I would remember.
Well, you say when she got a dander off, she'd stalk off.
Well, she was a good debater. She fought for her position. I don't remember her as being someone who was a pushover.
Well, was she a vindictive woman?
I think, Senator, that she argued forcefully for her position, and I took it as a sign of immaturity, perhaps, that when she didn't get her way, that she would tend to reinforce her position and get a bit angry. I did not see that as a character flaw or vindictiveness.
Did she have any indication to you that she wanted to be a martyr for the civil rights movement?
Senator, I can't answer all those questions. What I've attempted to do here is simply say to you that you indicated that she was meek and suggesting that she was not an aggressive, strong person. I remember Anita as aggressive, strong, and forceful in advocating the positions that she stood for. And again, there are others who worked with her, and I suggest that you have them come before this committee and you ask them. With respect to why, as I have sought through my own memory and my own recollection of what could possibly have happened, particularly at EEOC, the change in position where she was no longer my top assistant or my top aide, and she became one of many, and perhaps, and certainly not the most senior, and not the one who received the better assignments, and later not becoming the top assistant. That could have been a basis for her being angry with me, but that doesn't seem to be too much of a basis. I don't know, Senator. If I knew, I would not have been as perplexed as I am.
Well, did she ever show signs of being resentful?
I can't remember, Senator. I know that she's shown signs that she was upset when she did not get her way. But again, I'm not going to sit here and attempt to criticize her character. I can only say that during the time that she worked with me, she was not perfect, but there seemed to me to be nothing that would suggest that she would do this to me.
Well, did she at any time during the time that she worked with you as at the EEOC, which most of the allegation, at the Department of Education, where most of the charges that she makes against you pertaining to remarks about pornographic films and pornographic materials, and then she says it continued some, but there were more at that time. She was your attorney assistant, as I understand.
Attorney advisor.
All right. Did you at that time ever notice anything about her that would indicate to you that she was out of touch with reality?
Senator, again, that's 10 years ago, and my working relationship with her, she was professional and cordial, as I suggested this morning. It did not involve, and as I've indicated, any discussion of pornographic material or any attempt to ever date Anita. I view my special assistants as charges of mine. They're students. They're kids of mine, and I have an obligation to them. It's the same way I feel toward interns and individuals, co-ops, or stay-in-school students.
Well, we're still left in a great quandary, and we're trying to get to the bottom of it. After she went to EEOC with you, did she show any signs at that time of being out of touch with reality?
Senator, again, I'm not a psychologist or a psychiatrist, and at EEOC, I can tell you I was enormously busy and spent an enormous amount of time at the office, involved in any number of activities. At EEOC, the assignments, as I remember them, the individual in charge of the office, I had a chief of staff at the time, would take care of the assignments and would be more involved with the special assistants. My suggestion to you, as I've indicated, would be that this committee spend some time with people who work there. This committee has spent, I think, an inordinate amount of time with someone making uncorroborated allegations against me, and should have people who've worked with me who've not seen any such activity, who did not corroborate these allegations, and who had opportunities to work with and observe Anita Hill.
I believe, sir, that Chairman Biden has answered that in saying that they will come and will be available. But now at the Department of Education and at the EEOC, did any fellow employee of hers, did any supervisor of hers, of anybody else indicate to you that she was out of touch with reality?
The only one employee indicated very strongly to me during my tenure at EEOC that she was, I believe this may be a quote, on my enemy. And I refused to believe that and argued with him about that and refused to act in accordance with that.
Well, did he tell you any of the facts surrounding how he arrived at the opinion that she was your enemy?
Senator, as I said, I ignored it. Loyalty is something that was important to me, and I paid no attention to it. And he, in recent days, reminded me of what he told me.
All right, so now, was any other information that came out while you were working with her that would indicate to you that she lived in a fantasy world or anything?
Senator, again, I don't know. I'm not a psychiatrist or a psychologist. I was a busy chairman of an agency.
Well, here we are in a perplexed situation, trying to get to the bottom of it, and I'd ask you again, do you know of any reason why she might purposely lie about these incidences, alleged instances?
Senator, I don't know why anyone would lie in this fashion.
I believe that's all.
Judge, just because we take harassment seriously doesn't mean we take the charges at face value. And just as you have gone through and pointed out that when you work with Anita Hill and up until the moment that the charge was made available to you, to an FBI agent, you thought her to be a respected, reasonable, upstanding person. When a respectable, reasonable, upstanding person, professor of law, someone with no blemish on the record comes forward, this committee has the obligation to do exactly what you would have done at EEOC, investigate the charge. Because this is being investigated, you are making a mistake if you conclude that before all the evidence is in, the conclusion has been reached by this committee, by me, and by my colleagues. You've said some things tonight that are new information to us, assuming them to be true. First time I've heard that you were ever invited, drove home and/or invited into Professor Hill's apartment to have a Coke or a beer. You've told us things that are new. You should not, in your understandable anger, refuse to tell us more. We have to figure this out. For us to have concluded with a person of Professor Hill's standing in background that this is just something we're not going to look at would be irresponsible. I don't disagree with you that it was irresponsible the way in which Professor Hill ended up before us. I understand that. And if I had anything to do with it, I'd apologize for it. But in a very much smaller fashion, I was the other under that one myself. So do not, in your anger, tomorrow refuse to tell us more. This is not decided. Witnesses are going to be coming forward. The witnesses that you and your attorneys have asked us to hear. People we want to hear from.
Mr. Chairman, can I just make one last comment?
You may.
I hope that nobody here, either on this panel or in this room, is saying that, Judge, you have to prove your innocence. Because I think we have to remember and we have to insist that Anita Hill has the burden of proof or any other challenger and not you, Judge. The fact of the matter is the accuser, under our system of jurisprudence and under any system of fairness, should have to prove the case. And Judge, we will go into some things tomorrow, and I look forward to questioning again tomorrow, and we wish you a good night's rest, and we look forward to seeing you.
Mr. Chairman,
Let me
Mr. Chairman.
clarify one thing. I've been asked by one of my colleagues to clarify. I don't think you misunderstood it, but no one else should.
Yeah.
But I was referring to that what warrants an apology.
I wasn't referring to you.
No, I know you weren't. I wasn't referring. I was just referring to my comment.
Yeah.
I was referring to the fact that Professor Hill testified here today that her statement, which we attempted to keep confidential, was leaked to the press. That's what I'm referring to as being the injustice.
Mr. Chairman, if I just a moment, because I respect Hal Heflin and I came here to the Senate together, that class of 78. Great respect for him, and I see this terrible quandary that he is in because I've watched him work. Intimately, we have worked together on a lot of things. And it's the same thing we all feel, but there's a big difference here, and Orta's just touched on it, and that is what you said this morning, Mr. Chairman, in your very fair way, and I quote from your statement, and I think we must not forget this, and this is a quote from our chairman this morning: fairness also means that Judge Thomas must be given a full and fair opportunity to confront these charges against him, to respond fully, to tell us his side of the story, and to be given the benefit of the doubt. Now, that's what we're doing here, and if there is any doubt, it goes to Clarence Thomas. It does not go to Professor Hill.
I made the statement. I stand by the statement. That's why not that you need my recommendation, Judge, but tell us what you know. We are trying to determine what happened. It's as simple as that. And the mere fact, as I said, that we take the allegation seriously does not mean that we assume the allegation is correct.
Mr. Chairman, I might just say this. I believe you mentioned Clarence Thomas's attorneys. So far as I know, he has no attorneys. He doesn't need any.
Well, tomorrow we will reconvene. I assume, Judge, it's your choice. I assume you wish to come back tomorrow. The committee is not demanding you come back tomorrow. Do you wish to come back tomorrow?
I think so, Senator. I'd like to finish
We'll
this
reconvene at 10 o'clock.
That gavel smack. We'll reconvene at 10 o'clock. Bam! Strom Thurmond, maybe? I'm not sure who we're talking about. But that was it. That was what I wanted to get through today. I wanted to see here Anita Hill. You know, we started Anita Hill today. We finished the Anita Hill of it all. And then we also made our way through Clarence Thomas, which is I really wanted to see what he had to say about what Anita Hill had to say. And there's not a ton of policy that I can get through or case law. Like after we do a hearing, I usually have a few things to go through, whether it's like Roe versus Wade or affirmative action. But this is pre-brain surgery, David Smith. I like to think that's David Smith of the Libertarian Party, David Smith. But it was weird. You know, Biden, look, he almost was playing the role not as her like local counsel or anybody. There were points where she was kind of cornered, and it looked like he was like trying to interrupt that whole process. Like, well, the particular thing where she looked like she was cornered, if I can remember. Oh, what was it? It was about the policy positions. Like, what would you be willing to do to stop this conservative guy with positions that are, you know, against, you know, typical liberal policy planks, let's say. What would you do to stop him? Would you be willing to do this? And then Biden was like, whoa, 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 whoa. we can't go there. And that was like, oh, that's a weird exchange right there. There was some funny stuff that came up, like her attorney just kind of stood up out of nowhere and said, I'm, looking like Orville Redenbacher. Straight out of Central Casting. That was 20 minutes in. It was quite the moment. It didn't happen again. You don't do that in a hearing. But, yeah, there's a few moments, but the most powerful moment that I think I wrote down here was that the way in which Clarence Thomas defended himself and his career and his record. It's the Hormozy, right? Alex Hormozy says, don't do these, affirmations in the mirror. Just, you need to have a stack of evidence, that's irrefutable, that you could say, I bust my ass every day. That's essentially what Clarence Thomas's argument was. I bust my ass. I've worked with tens or hundreds of women, and no one has come out with these allegations, and rightfully so. Jesse Jennings pointed this out. It's like, how many people like this, like the type of person that we're describing here, has just one person that they pray after? I feel like it's unusual. It is. It doesn't just happen in a vacuum, or it could happen, right? But it seems out of character, not lockstep. It just doesn't match, right? Doesn't match the stack of evidence that Clarence Thomas has. His career, before the Supreme Court nomination, he was the chairman of the Equal Employment Opportunities Commission. And Anita Hill, I'm not sure if she helped him prepare for that or testified in his favor. But there was, it would be weird. It seems like she was either lying then by omission or lying now, fabricating the story. So, like I said, there's not a ton of case law to go over, but it is a good example in what I think is something that's politically timed, right? You see this happen sometimes. Julian Assange, Donald Trump, Clarence Thomas, Kavanaugh. It almost seems to be a one-way street. Then occasionally you get someone like Bill Clinton, and it's like, where's the evidence? And there's literally a dress that's stained. I don't know. Look, you can't go and say like no Republican has ever, sexually harassed a woman. But it seems like when it is a Republican, there's no evidence and it's all hearsay. It seems to be like a politically motivated play out of a book, right? Look, this is just my hot take. How many examples, concrete examples, other than Bill Clinton and Monica Lewinsky, do you have of this kind of thing happening? Lawfare is a thing. David Smith, got your finger on the pulse of the issue. It's one of the reasons I started this channel. Is like I just become an attorney, and then all of a sudden, out of nowhere, there's I don't know if it's out of nowhere, two-tiered justice system. It's like, what am I supposed to do? Wait another 10 years before I can speak up and say something? So many attorneys are siloed in a way. That means that, you have personal injury guys, and they only pay attention to personal injury cases. Admin guys paying attention to admin. Everybody's paying attention to their own field, and it just seems like there's not enough people speaking out against the two-tier justice system. Like, if you're not Clinton, if your name's not Biden, what other names are there, It seems like no investigation, If your name's Donald Trump, you're in trouble. So, yeah, and that's the other thing is, and for anybody in the chat, listen, you could say, Clarence Thomas has accepted gifts from his rich friends, and that's true, but those rich friends never had any business before his court. But, what do you say about Kamala Harris, who was a district attorney in the state of California, who did dismiss cases against her donors? And this is something I've been harping on, but I think it's extremely relevant. Anybody who comes in here saying, Thomas went on a jet, took a vacation in an RV. Like, yeah, but he didn't dismiss any cases. There's no credible evidence of cases dismissed against people with business before his court and him. But there is credible evidence that Kamala Harris did just that. Which is why I think we're going to see, thank you, Cats. Thank you, Cats PJs. Which is why I think we're going to see less of the Thomas rhetoric, because I just don't see them being able to overcome the Harris of it all. So that's all I got. It's 11:30. Holy cow. We made it through Anita Hill. and Clarence Thomas. I think there's going to be more, but we're probably not going to do too much other witness testimony. I do want to get to Ruth Bader Ginsburg. Look, I don't want to just go hard in the paint on one side. I do want to see how Ruth Bader Ginsburg responds to, Republican senators who are scrutinizing her. Obviously, Democrats are probably going to be more, amenable to confirming her, but I think we can expect to see Republicans put up a little bit of a fight. It's natural. And I want to see that, and I want to see her response and how she holds up to it. Her and Scalia were famous friends, and I think that's kind of cool. So that's where I'm at. Could start tomorrow. It depends on what Jacqueline Leah says, but I really do appreciate you guys. If it was just me, I don't think I can get through it all like this. An hour here, an hour there, but this is a lot of fun. So I really do appreciate it. Thank you so much. I'm gonna go upstairs and hang out with my wife, even though she's hanging out in the chat. Very cool. I really appreciate that, Jacqueline. Thank you. Thank you to everybody else. Alex, Mark, who else? Jesse, you got to join. If you don't join, just hang out long enough. We'll give you a membership. David, thanks for coming, dropping in. David Smith, that is. Who else? Who else in here? Oh, there's a lot of, bookworm. We'll get you right, sir. You just need to be careful. I think some of the things you said could be inflammatory. The emojis. Who am I to say, right? Mark Livgren. Thank you. Big dog. All right, everybody. That's all I got. We'll see you tomorrow. Keep an eye out for the clips. Subscribe. Knowledge is power. That's a shout out to my 8th grade English teacher, Mrs. Graham. Knowledge is power. Subscribe for more. I'll see you soon. Be well. Let me know if you need anything.